You're like, yeah, see, then where I got all spread out. We were all over here. Yeah. Why not on a jam? No, I'm looking for you. We should all move. I like that idea, moving every time.
I got to download that Zoom thing, just in case I have to.
Yeah, I actually went to go, the reason I'm early is because I wanted to see if Cy was here. But he left, so.
He always leaves early.
I have his phone number. Do you need his phone number?
No, I was gonna, he gave me the information that I needed, but I just wanted to, just in case there were days I have to stay.
Right.
And in San Bernardino. And at least I'm already set up.
Right, right.
Look at that. Spread out and
Taking
get the different sides, and that didn't take long.
Straightening out.
Yeah, no. Paper tool do that?
Just for my.
That's the again?
We go to the backpack, but.
Do we do both?
I don't know, I sent him a call.
That's keep the film.
Fail.
I'm actually not ready for this class tonight.
Really?
No.
They don't think it. No, it's kind of like, no, it's okay. I think it's a little dry, maybe we'll fix it.
Did you rest this weekend?
Thank you. Rest.
Dude, get a little tracks
We
there.
went after the baby, we have our flight.
Yes. It's maybe 3 hours.
That's true. We gotta
Yes, how many packs?
Yeah.
I don't have any contract notes, I was just on far, but I looked through my contract. One CD. We had books like 80 tracks, you know, and we usually hand out respect. So we just wrote inside. And I took my comments.
And why is one of these filled out and one of these not? Brian and Daniel, you guys are the rebels. You only, I don't know why we had two, but there were two there, so I signed them both.
Oh.
You see, they said I failed because I signed both of them.
I'm gonna remain a rebel.
Well, I'm not keeping one for myself,
Okay.
so I'm turning one in, but I don't know if they want two for any reason, because I usually just put one copy there, so. When you get a chance, I'm gonna ask all of you guys to make sure you've signed both. And then I will check to see if there's a reason why we're getting two or if we just need one. Plus we can buy time. So we had a faculty meeting, so that's unlike him. unless something came up. All right, guys, let's go ahead and get started. When his honor gets here, we'll just let him catch up with us. So one of the things that we like to do right from the get-go is to review the rules that we're going to be going over that night, okay? Part of the reason that we do it is we want to get you familiar with how the statutes are written. You'll start seeing patterns like, oh, I've seen this rule structure before, and you'll see what matters and what doesn't. And if we're telling you, hey, this is the rule, and you're not able to get that from the language that we're reading, you need to say something, right? You need to say, hey, how are you getting that rule? That's not what I get out of this. So we would just ask that you speak up and let us know, and we will go over those. So tonight we had 6. You will see as we go through them, there's not really 6 that you need to know from these first 6, but you need to know that they're there. All right, and that's as much a part of understanding evidence is understanding what is in the rules, such that if you ever do need it, you know it's there and you know that you can go back and search for it. So 101 through 106, these are the general provisions. Okay, these have a lot to do with procedure. You'll see that the rules of evidence are generally broken down into 9 different categories. You don't need to know these, you just need to know that there's about 9 different categories. The first ones have to do with procedure. That's the 100s, the 200s, and the 300s. Talk about how you go about procedurally doing things. 400s are relevance, right? 500s are privilege. 600s deal with witnesses and competency issues. Of course, 602 has to do with the personal knowledge rule. That's kind of singled out from the competency issues. 607 to 610 have to do with impeachment of witnesses. That's kind of a secondary category. So you need to know with regards to witness, you're going to have competency rules, you're going to have personal knowledge rules, you're going to have impeachment rules. We get to the 700, that's where the opinion rules are. 800s, that's where all of the hearsay rules lie. And then when you get into the 900s and the 1000s, those have to do with exhibits and how you go about getting those exhibits into evidence. So let's take a look at Rule 601 through Rule 101 through 106. Quick note on the book, if you haven't noticed, you will. Back in Appendix 1, there's a list of all of the rules. Many of the rules that are discussed in the chapters, you'll find at the beginning of the chapter. Those are not always complete rules. Okay, those rules that are in the beginning of the chapter might only be one section, and there's subsections that are left out. So just know when you're reading those rules at the beginning of the chapter, you might not be reading the whole thing. Okay, so when we go through them, we're going to go to the back. That way you can ensure that you're seeing the whole rule and understanding everything that's there going forward. Okay, 101 talks about what the scope of the federal rules of evidence are, and it's going to give us definitions. These rules apply to proceedings in U.S. courts. The specific courts and proceedings to which the rules apply, along with exceptions, are set out in Rule 1101. That's a very common statutory construction, right? It will tell you, these rules apply to X, I'm not going to tell you what X is. I'm going to tell you you could find X over here, right? And then you got to go to 1101, right? And if we go to 1101 just real quick, just so you can see it and you can piece it together. (1101) says these rules apply to proceedings before U.S. district courts, U.S. bankruptcy and magistrate judges, U.S. courts of appeals, U.S. Court of Federal Court Claims, district courts of Guam, Virgin Islands, and Northern Mariana Islands. So those are the courts that these apply to. Now the cases and proceedings, they apply to civil cases and proceedings, including bankruptcy, admiralty, maritime cases. They apply to criminal cases and proceedings, and they apply to contempt proceedings, except those in which the court may act summarily. Okay, that's an exception you're going to want to know, right? Hey, these rules apply in contempt proceedings. Well, not if the court can act summarily, right? Rules on privilege. The rules on privilege apply all stages of a case or proceeding. Exceptions. These rules, except for those on privilege, do not apply. This is another very common statutory construction, particularly with evidence. We're going to say the rule is A, unless B, C, D, E. And there's always a lot more exceptions than there are the general rule. So just know that you're going to have your general rule, but the meat and potatoes are going to be those exceptions to the general rule. All right? So these rules do not apply to the court's determinations under Rule 104 on a preliminary question of fact governing admissibility, and we'll get there. They do not apply to grand jury proceedings. They do not apply to proceedings such as extradition, rendition, issuing an arrest warrant or search warrant, a preliminary examination in a criminal case, a sentencing, granting or revoking probation, considering whether to be released on bail or otherwise. Okay, so just for example, we're in criminal court, right? And we're having a discussion about whether the court should grant this person probation or not, right? And the defense attorney says, well, I think you should grant him probation because I've talked to his mother, and his mother assures me that he's got a home and a place to live, and somebody's going to be there at all time, and there's going to be there to supervise him. And the objection, Your Honor, hearsay, right? And the judge will say, well, defense attorney, sounds like hearsay to me. How does that come in? Like, well, Your Honor, 1101 D3 provides an exception that these rules don't apply. And proceedings where we're talking about the grand or revoking probation. Okay? Or you don't know the rules and you say, well, Your Honor, it's not really hearsay. Whatever you say. I don't know what you would say to that. Okay? Most attorneys think the rules apply to everything. Everything. And they object all the time, even when the rules say they don't apply. So if you know those exceptions when they don't apply, score a couple points with the court, show them that you know a little bit, and let them off the hook. Okay? And lastly, E, other statutes and rules. A federal statute or rule prescribed by the Supreme Court may provide for admitting or excluding evidence independently from these rules. Okay? So that may be a rule of the U.S. Code regarding civil procedure, or regarding criminal law, or bankruptcy code, right? There's some other statute besides the rules of evidence that talks about the admissibility of certain types of evidence. If there's another rule and another statute that talks about it, then these rules don't apply. You use that more specific rule. Okay? You gotta know some definitions. That's very common. When you are arguing a statute and you're arguing the words in the statute, you need to know what the, if there's a specific definition for the terms that you're trying to use. And 101 does just that. If we're talking about a civil case, we mean a civil action or proceeding. Criminal case means a criminal proceeding. Public office includes a public agency, right? So if you're making an argument that this rule needs to apply to a public agency and somebody says, well, that's not what the rule says. The rule says public office. Well, yeah, and the definition of a public office includes a public agency, right? Record includes a memorandum, report, or data compilation. A rule prescribed by the Supreme Court means a rule adopted by the Supreme Court under statutory authority, and 6, a reference to any kind of written material or any other medium includes electronically stored information. Okay, so these are definitions that are set out right at the beginning of Rule 101. Okay, and those definitions will carry through the rest of the code.
Sorry.
Okay, so if you see public office or record or any reference to a kind of written material, the definition for that will bring you back to 101 to talk about that. We just went over the very first rule.
Yeah. Rule number 1. Yeah.
Rule
number 1.
Rule number 101. Okay, so you're not going to be called to really talk a whole lot about Rule 101, but you need to know it's there. You need to know what's in it so that if you need, hey, it seems to be talking about a definition of some sort. What were those definitions? Oh, yeah, those 101 had that. And you know to go back and use it. 102 talks about the purpose, right? These rules should be construed so as to administer every proceeding fairly, to eliminate unjustifiable expense and delay, promote the development of evidence law to the end of ascertaining the truth and securing a just determination. Good language in there. Okay, what does it mean? Not much. It just tells you, hey, these rules are to help you get a fair trial, right? And to save money, right? And to promote the ascertainment of truth and all those things. But that's good language when you're trying to make an argument to the court and you're trying to make a point. And they're like, Your Honor, the whole point of these rules is we're supposed to be searching for the truth, right? And we're trying to secure just determinations. And in order to do that, you need A, B, C, and D. Right?
Or in order to, we want to avoid unjustifiable expense, right? Delay. Yeah. So when you are finding yourself making a policy argument, here are some policies that you might refer to.
Questions on that? I mean, so there's not really a rule, but it just tells you what the purpose is, and that's good language to carry with you throughout. Right? Those are good type of arguments to have in your back pocket. They just sound good. Okay. 103, rulings on evidence. Right?
You will need to know this one.
Right? Preserving a claim of error. A party may claim error in a ruling to admit or exclude evidence only if the error affects a substantial right of the party. Okay, and we'll talk about what substantial rights are, but it's got to affect the substantial right, and if the ruling admits evidence, a party on the record does these things, right? So if you want to preserve a claim of error, it's got to affect the substantial right, and you have to do these things on the record. Timely object or move to strike, and state the specific grounds unless it was apparent from the context, or If the ruling excludes evidence, a party informs the court of its substance by an offer of proof unless the substance was apparent for the context.
So these are two sides of the same coin. If the evidence comes in, what did you have to do to preserve your objection? Make it on the record, timely make it, and state the specific ground. Flip side of that coin, if the ruling excludes evidence, what do you have to do? Make an offer of proof. Tell the judge, here's what the evidence would be if you let us present it. Everybody see how those are like mirror images of the same thing? Okay.
And how much do you see in real practice? Not much. All right. Attorneys do a very poor job of preserving their claims of error. Bottom line is, at the end of the day, you lose, you want to appeal, the appellate court is going to be bound by the four corners of what's in the record. And if you didn't say what your objection was, or you didn't object, and you didn't give grounds, or you didn't make an offer of proof of why this evidence was important to your case, why it was relevant and admissible, the appellate court has no basis by which to overturn the trial court. They don't know why you might have been right and the trial court wrong, because you didn't put that on the record. So it's important to do.
And just from a policy perspective, why do we want you to make a specific and timely objection? Why do we want you to make an offer of proof? So the trial judge can get it right, right? Give the trial judge a chance to know what the objection is, why you're objecting, so that the trial judge can rule on it. If you just bring it up later, it's like, well, wait a minute. If you had said that at the time, maybe you wouldn't have a problem, because maybe the judge would have gone, yep, you're right. So the goal is to avoid error in the first place by making you, if you're objecting or offering evidence, timely object and specifically object and timely make an offer of proof so that you can avoid the error in the first place.
B, not needing to renew an objection or an offer of proof. Once the court rules definitively on the record, either before or at trial, a party need not renew an objection or offer of proof to preserve a claim of error for appeal. Important note there, right? You need not renew. So it doesn't mean you don't have to do it. It means you've already done it. The court has now ruled, and you don't need to do it again. Okay? What do attorneys do? They do it again all the time, right? You'll have a pretrial hearing. Your Honor, I want to offer this piece of evidence, and the opposing counsel will object. We object to that coming in. The court will rule, no, I think it comes in, and it's coming in, right? You give your opening statement. Ladies and gentlemen, you're going to hear about X. Objection, Your Honor, for the record. We got it. We got the objection when we did the pretrial hearing, right? And then when you call the witness and you try to offer it, they will object again. Why? Makes them feel good.
Know that they objected,
right? They don't have to. It's already been preserved. On a side note, not dishonor,
No.
but I had a judge change. I had a judge rule in pre-trial that something comes in, and then when I offered it, the defense objected, and the judge sustained it. You're wrong.
Things develop.
We talked about this, didn't we? So, for what it's worth, it might help you out.
If circumstances do change, don't hesitate to ask again, right? Look, Your Honor, I know in pretrial motions you agreed to admit this exhibit, but now we know that it's not actually admissible because we learned this since that, and
Okay, court statement about the ruling. The court may make any statement about the character or form of the evidence, the objection made, and the ruling. The court may direct that an offer of proof be made in question and answer form.
So in other words, instead of just saying, if this witness is called, he'll testify that blood is green, like, okay, tell me, what would you ask and what do you think the answer would be?
Okay. That's basically telling you the court has discretion to handle this how it sees fit. Okay. Preventing the jury from inadmissible evidence to the extent practicable. The court must conduct a jury trial so that inadmissible evidence is not suggested to the jury by any means. Okay, that's the court's responsibility. But it's also your responsibility as a lawyer. Right? If you got something that you know is a hot issue and you know the other side is going to object to it, you better bring that up outside the presence of the jury. Don't try to sneak it in the first chance you get. Just make sure that if you know it's something that's going to be contested, seek a ruling pre-trial. Courts appreciate it, the juries appreciate it, and your trial will run so much smoother, right? I've been in trials where it seems like every hour on the hour, we're taking a break, my jury, could you excuse us? We got to discuss an issue. Right? And it just drags on, and they sit outside for half an hour, then they come in, oh, we need you to step out again. And you argue another issue. And I've also had trials where we addressed everything up front, and we never had to excuse the jury. The trial just flowed. Okay, and if you're the one who's presenting the trial, clearly an advantage to you to present one without interruptions. Okay, it doesn't look good. You have to keep taking breaks, and the jury doesn't appreciate it when you keep sending them out in the hallway and say, why don't you stand out there and twiddle your thumbs for half an hour while we think these things through. Okay. Taking notice of plain error. A court may take notice of a plain error affecting a substantial right, even if the claim error was not properly preserved. So we've talked about how an attorney preserves their claim of error. If the attorney is asleep at the wheel, right, and they don't preserve their claim of error, and the judge sees it and knows it's affecting a substantial right, the court can take notice of that on the record on their own.
Don't count on this happening if the error is against you.
And don't sit back and say, well, Judge, you didn't see it, so why don't you have an obligation to say something too? We need to do our jobs. So 103 is basically a rule laying out practically how you go about handling your objections and preserving your issues for appeal. How do you go about doing that? You're going to do it by being specific and timely in your objections. You're going to be doing it by making your offers of proof to the court and making sure all of that is on the record. Once you preserved it, who knows, right? You might win the trial and it becomes a non-issue, okay? But you don't want to be in a situation where you need it preserved and you didn't do it, okay? So 104, right? Remember, we talked about 104, and when we looked at 1101, right? 104 was one of those exceptions, preliminary questions of fact. Right? The court must decide any preliminary questions about whether a witness is qualified, whether a privilege exists, or evidence is admissible. And so deciding, the court is not bound by evidence rules except those on privilege. So, why is that a good thing? When you're in a pre-trial hearing and you're trying to address any of those things, witness qualifications, whether there's a privilege, whether evidence is admissible, the rules of evidence don't apply, right? So when you get those objections based on a rule, right, Your Honor, this is a pretrial hearing, right? You're not bound by that because the court is trying to make a determination and it needs as much information as possible.
You can rest assured that you almost certainly will see that on an exam.
This is one of those you need to know. And this is one of those, again, that is on a practical matter. Attorneys don't seem to know it, and they don't seem to practice it. They will go into every pretrial motion and they will object to using every rule in the book as if it is not a rule, that it doesn't apply. B, relevance that depends on a fact. When the relevance of evidence depends on whether a fact exists, proof must be introduced sufficient to support a finding that the fact does exist. The court may admit the proposed evidence on the condition that the proof be introduced later. So this is kind of a conditional relevance type situation. It's where you're telling the judge, look, I've got this evidence right now. I know on its face it might not seem relevant. I'm gonna tie it up later with another witness. And when you hear everything, you'll see how it's relevant. Some judges will say, no, I want to hear it now. How are you going to tie it up? Some judges will say, okay, I'm going to let you proceed. And if you don't tie it up, I'm going to exclude it all. Okay. One example might be, I don't know if you guys followed the O.J. Simpson trial, right?
You've heard of O.J. Simpson, right?
Right.
Famous trial 20 years ago, whatever it was.
Right, and the O.J. Simpson trial, part of the evidence that came out in the civil case was his shoes, right? The infamous Bruno Mollies.
He wouldn't be caught dead wearing those ugly ass shoes.
Right? And so, right, we want to introduce evidence that there's these shoe impressions in the blood at the scene. What's the relevance of that? Well, it's at the scene. I just want to offer it because it was at the scene. Right? No, you've got to, why is the shoe impression itself relevant? Well, this witness isn't going to give you that, right? This witness is a forensic photographer. He's on the scene. He's taking pictures. Did you take pictures of these shoe impressions? Yes, I did. Okay. Another witness will come in and say, did you review these pictures? Right? Did you review these shoe impressions? Yes, I did. Did you do any sort of comparison and draw any conclusions from that? Yes, I did. At this point, what's the relevance? Right? You haven't tied them to the scene, you haven't tied them to the defendant, but you've got a second witness who's going to say, I compared them, and in my opinion, based on the tread, I'm going to say it's a Bruno Molly shoe, it's a unique type of tread, and based on the size that's there, I'm going to say it's a size 12. I don't know if that's right size for OJ, but that's my example, right? And then someone else is going to come in later and say, have you seen this picture? Yes, I have. What's that a picture of? That's a picture of O.J. Simpson. You know what kind of shoes he's wearing? Maybe that person doesn't know. I don't know. It's like he's wearing some brown shoes, right? And then a fourth person's going to come. Can you look at these shoes? Can you tell us what type of shoes those are? Yes, I'm an expert in Bruno Mollies, and that's a Bruno Molly shoe. Okay, so your initial witness can't lay the foundation for ultimately what you want to bring it in for, right? And it's going to take potentially 3, 4, maybe 5 witnesses to get to the point where it makes sense and it's relevant. Okay, sometimes the court will say, I want to hear it, tell me how it's relevant, and they'll make a determination based on the counsel's representations. Sometimes they'll let you do it in court. Well, I'm not going to rule on that yet. I'm going to see if you can tie these things up. And then after each witness, you'll say, you know, I've tied this up, and they'll say, okay, yeah, this is admissible. Or not. No, I don't think you did. Or they may say, I want to hear from all the witnesses pre-trial. bring them in. I wanted you to question and answer each one of them so I can make a determination on whether I'm going to let this evidence come in. Okay? You don't want to be in the middle of trial figuring out which way your judge likes to handle that. If you know you've got that type of evidence, address it pre-trial. Say, Your Honor, I intend to offer this type of evidence. How would you like me to proceed? Okay. And usually the court will take whatever factors are present. I had a similar such case one time where I had Nike Cortez, right? What's so significant about Nike Cortez? Just that every gangbanger in California wears Nike Cortez.
The shoe of choice.
A shoe of choice. However, my expert was the head of Nike operations in Oregon. Piece of cake, right? I said, he says, yeah, I'll come down and I'll testify for you. Well, by the time we got to trial, he had been promoted. And he now was a head of operations in Asia. And his office was overseas. Still willing to come back and testify. You know, he had done all the work on it. Your Honor, my witness is coming from overseas. Might not be practical to have him come pre-trial and testify, but here's what I would anticipate his testimony to be when he comes to testify before the jury. I think we can tie this up. The court agreed and let me do that. If he hadn't, I would have had to bring him in pre-trial. And then guess who my first witness would have been? My shoe guy. And the jury's gonna be like, what? You're completing your case with your shoe guy? Yeah, because I need to get him on a plane out of here because he's costing me a lot of money sitting around. So, you know, sometimes those practical considerations that come into play.
Yeah. One way to think about this is do the Bruno Malley shoe thing backwards. Your Honor, I'd like to offer a testimony from an expert witness saying that these shoes in this photograph are Bruno Malley shoes. Okay, and why the hell do we care about that? Oh, well, because we're going to have another witness come in and say that that's a photograph of O.J. Simpson wearing those shoes. And then another witness come in and say there were bloody foot or shoe prints at the scene of the crime that matched Bruno Malley's shoes. And then, you know, right? So if you think about it that way, it's like, oh, that's why the judge gets to say, okay, we'll let you put in the evidence of the picture of O.J. wearing the Bruno Malley shoes, even though it doesn't seem to matter a whit right now, because you're going to be able to tie it all up and say, and as a result, we know that those shoes were on those feet that night at that location, right?
Okay. And last, there in part C, conducting a hearing so that the jury cannot hear it. The court must conduct any hearing on a preliminary question so that the jury cannot hear it if the hearing involves the admissibility of a confession, the defendant in a criminal case is a witness and so request, or justice requires. Okay, those are just three kind of common sense things, right? If you're doing a hearing outside the presence of the jury, the point is that the jury doesn't hear about this, okay? So assuming the jury is already in place and you're having a hearing about a confession or the defendant's going to be testifying and he asks, or on any issue that justice just requires, you need to make sure the jury can't hear. And where do you think jurors congregate when they come in for their jury service? Right outside the door of your courtroom. So if you're inside arguing about whether the defendant's confession should come in, right, and you're playing excerpts of it, and they can hear it through the door, and then the judge says, I'm not letting this in, right, and then everybody comes in, well, we just heard this guy confess, right, doesn't really make for a fair trial, okay? So usually when you're having these types of sensitive hearing, the judge will schedule it at a time when he knows the jury's not going to be there. You don't schedule it. Hey, we'll be in here at 8:45 and the jury's gonna be here at 9. Right, because some jurors gonna be here like 8 and sit outside. There's always that one juror. So.
And by the way, when you're having this happens all the time. You're having a phone conversation in the hallway with somebody, your secretary, a witness, an investigator, or whatever. Remember, keep your voice down, because there's always going to be a juror or somebody around that you want to hear your phone conversation. And it's really embarrassing to have, like, and this happened to me. As a lawyer, I had the juror tell the judge, I heard Mr. Hopp in the hallway talking with, oh, we're supposed to hear that.
So, cross-examining a defendant in a criminal case. Now remember, we're still talking about pretrial hearings at this point. By testifying on a preliminary question, a defendant in a criminal case does not become subject to cross-examination on other issues in the case, right? For example, maybe they want to challenge the validity of the search, right? And the cop says, I think they gave me consent to search. Well, the defendant wants to take the stand and say, no, you didn't, right? He's allowed to take the stand and say, for this preliminary question hearing, I did not give consent for the officer to search me or to search my vehicle or what have you. And then the DA stands up because they want to cross-examine them. Oh, so you didn't give consent? Nope. But you sure had meth in your pocket, didn't you? Right? No. Just because they're testifying about a preliminary question, that doesn't open them up to cross-examination on other issues.
Another example about this is the admissibility of a statement that was given without Miranda warning, right? Or one that was given with Miranda warnings, where the advisement's given. The defendant can get on the witness stand and testify, no, the police officer never read those warnings to me, didn't advise me I had the right to remain silent, didn't tell me I was entitled to an attorney, didn't tell me that I could get an attorney without any cost to me before any questioning, didn't tell me any of those things. And the district attorney can't, on cross-examination, say, get into the content of the statement, right? So you can get on the, because if you didn't have this rule, then the defendant's screwed, right? The defendant couldn't ever testify about the admissibility of a statement without also having to testify about the whole statement. And that's just unfair.
And the last part of 104, this rule does not limit a party's right to introduce before the jury evidence that is relevant to the weight or credibility of other evidence. Okay, sometimes you want to offer something in evidence that might not be admissible on its own, right? But you're not offering it as a standalone piece. You're offering to demonstrate the weight or the credibility of another piece of evidence. Okay. One type of example is if you have an expert who's testifying, right? And they're giving their opinion. And their opinion is, hey, well, this evidence that I want in, I know it's not admissible, but it goes to the weight and credibility of the expert's opinion because it demonstrates how they went about forming that opinion. For example, maybe the defendant's statement is admissible, right, for a Miranda violation or whatnot, but you want to be able to ask, did you consider a statement by the defendant? Right? Well, that would be important. He's given an opinion about whether he thinks the defendant is competent or not, right? It might be important whether he actually considered a statement by the defendant. Well, the statement's been ruled admissible. Well, I'm not going to want to get into the substance, but I'm going to want to get into the idea that this expert considered this type of information in forming their opinion. So the weight to give it and credibility to give this witness is dependent on it. And sometimes the judge will do that. And they'll give instruction to the jury that this is being admitted for this purpose. And you can get in for that. Okay? Just another way to, if you don't know that it's an option, right, you know in your mind, wow, this is really helpful because right, it lends credibility to what my witness is saying, but no, it's not admissible, so I can't get it in. Well, there's ways to around that with regards to the weight issue. Okay, 104 is a pretrial hearing. You don't need to know this yet. In California, they're 402 hearings. They are hearings before the court, so the court can make a determination about preliminary questions for the trial. Okay? The rule of evidence do not apply in these 104 hearings. Okay? That is an important concept. Know it. Know the rule. You will see it again. Okay? And know that there are subparts to it. A conditional relevancy part, right? If you want to argue, right? You're going to get an exam that's going to talk about, hey, talk about the admissibility of these shoes, right? This witness, and this. What do you got to say? Well, a judge will conduct a hearing under Rule 104, and under 104B, right, he can make a determination whether to admit it because the relevancy of this fact depends on another fact, and how procedurally you're going to go about doing it. Right? You need to know that that is something contained within 104. But the main gist that we want to take away from is the rules of evidence don't apply, except the rules regarding privilege. Okay? And if you think about it, that makes sense. Right? If somebody's going to come in and assert a privilege in a 104 hearing and say, you can't call me as a witness because I've got this privilege, then the court's going to need to look to the law to determine whether that privilege exists or not. Okay?
You can't, once the privilege information is out of the bag, it's out of the bag, right? Once that privilege, that attorney-client privilege, that spousal privilege, protected information is disclosed, it's disclosed. Well, great. The whole point of the privilege was nobody would have to talk about what those two people talk about. So we can't make you talk about it to decide if it's privilege. Does that make sense? Everybody? Right? Because if you force people to talk about the privileged information, what's the point of the privilege?
105, also an important rule for you to know. Okay? And this is probably a good place to just point out. I want to make sure you guys understand. When you are asked about rules on your exam, okay, we expect you to know the rule and provide a good rule statement before you analyze that respective rule. Okay? You don't have to say 104, 105, but of course, we're humans, we're impressionable, right? And if you say, well, pursuant to 104 sub C, right? 1, this hearing involves the admissibility of a confession, we're going to step back and say, wow, you're right, good. You don't have to know the numbers and the code sections. And if you put a number, make sure it's the right number.
Yes, absolutely. If using the wrong number is like bad. Better not to use the number and let us like go, oh yeah, they know the rule. They just don't remember the number, then to like use the wrong number.
Okay. The important part is that you know the rule and are able to articulate what the rule is. Okay. So you don't need to know the numbers, but you need to know the rule. And the importance of that is these rules cross over to other jurisdictions. California evidence does not have these numbers. It has most of these rules, plus some. California, we've got more than the federal rules. Okay, but these rules for the most part are the same, right? So you might not know the number, but you can ask the court for a limiting instruction, right? That's
do you have any tips about memorizing these rules? Because if you compare these to like what we learned last year when we were learning more substantive law, the rule statements were a lot shorter. So I just wondered if you had any like, tips on how to go about memorizing a rule as long as 104 with all the subsections.
okay. The key for 104 really is knowing and understanding the parts, right? 104 is talking about pretrial questions, preliminary questions. It's a hearing process where the court does these things, right? It addresses conditional relevance. It talks about the judge, making sure that the jury doesn't hear in certain situations, right? It talks about the cross-examination in a criminal case in that hearing, right? And it talks about weight and credibility of evidence. If you know those things and you understand those things, then when you start to write down the 104 rule that applies, that's what you're going to write, okay? If you don't understand the rule, it's not going to make sense to you,
Right.
and then you're going to have to memorize the whole thing so you can just write it down by memory. If you understand it, there's no need to do that, okay? And you'll see as we get to some of these other rules, okay? 105 is a good example. And 105 is limiting evidence that's not admissible against other parties or for another purpose. If the court admits evidence that is admissible against a party or for a purpose, but not against another party or for another purpose, the court, on timely request, must restrict the evidence to its proper scope and instruct the jury accordingly. Okay, so I want a piece of evidence in. I call somebody in as a witness and they say, I just saw a white guy in a black hoodie, wearing Nike Cortez, running that away. And they're talking to a cop. And that witness is gone. Right? And I want that witness in. Right? And it's hearsay, and the court makes a determination. There's no exception for it. Right? But I say, Your Honor, I'm not offering it for the truth. Right? I'm offering it to show what effect it had on the listener, because the officer then ran that away, and 20 yards away, he found a gun on the ground and a black hoodie on the ground, and we've tied those to the defendant, right? So I want to use it not for the truth that this person actually saw somebody doing that, but for some other purpose. And the judge will say, right, the other party will object, but they'll say, well, if you're going to let it in, Your Honor, I want you to instruct the jury. And the judge will say, jury, you're not to consider this for the truth of the matter, but for the limited purpose of what effect it had on the listener.
And as we know, juries always follow that instruction to the,
Right? And that has a couple of effects on your case. Number one, it limits how you can argue it. Right? You can't then stand up in argument and argue that witness saw that. Right? All you can say is that witness said that, and the officer went the other way. And you let the jury then connect it, like, well, yeah, that witness really said that, and it was true. Right? You can't argue that it was true because the judge has instructed you that they're not to consider it for that other purpose. Okay? Or maybe it's against another party, right? You've got a couple of guys. One guy says, yeah, we did it together. The two of us broke in and we burglarized his house. And the other guy says, I'm talking to you. I don't say it. I got nothing to say. DA wants to use that confession. Hey, this one defendant has just confessed to committing a crime. Well, do you get to use it? Probably, if Miranda was appropriate and whatnot, and it was voluntary, you'll probably get to use that statement against that one party. You're probably not going to get to use it against the other defendant unless this guy takes a stand, right? The guy who didn't give a statement can't be convicted based on what his co-defendant says, pointing the finger at it. So the judge could limit it, right? You've heard this statement. You're only to consider it as to this party, this individual. You're not to consider it against the other party. Okay? That being said, right, that's a whole lot of words for this idea that if evidence is limited for a purpose or a party, the judge needs to instruct the jury accordingly.
If you request it. Notice that the judge doesn't have a duty to instruct the jury that way on his or her own. You got to make a timely request.
And then sometimes you don't want it. Right? I've had cases where, you know, we go through this long, drawn-out hearing, right? And the jury may have already heard it, right? And now the defense is saying, well, we want a limiting instruction. And then they start thinking about it like, well, if you give a limiting instruction, it's just going to highlight that particular piece of evidence. And we don't necessarily want you to highlight it. No, we changed our mind. We don't want it. Yeah, we don't want it. Right, let's just leave well enough alone. Let's move on.
So that's another reason why you have to make a timely request, right? Because you may decide to attack a matter. Forget it. The limiting instruction just calls attention to the bad.
106. Also one of our early rules that you need to know, okay? Remainder of or related writings or recording statements. If a party introduces all or part of a writing or a recording statement, an adverse party may require the introduction at that time of any other part or any other writing or recorded statement that in fairness ought to be considered at the same time. Right? So one side stands up and says, Your Honor, I'd like to introduce this writing. I've got the witness right here. And what does that first paragraph talk about? Right? Well, it talks about how the defendant went about taking the money, you know, out of the safe and stuffing it in his coat pocket. Okay? And the other party says, whoa. That mischaracterizes that whole thing. I want the rest of that statement read right now. I don't want to wait till my case. I want them to hear it right now. And what does the rest of it say? Right? The rest of it says, hey, I'm going to go down to the bank right now and I'm going to put this in, your account. I've got your deposit slip and I'll bring you a receipt back and we'll be done with our transaction. We'll kind of change the perspective there, right? And it's like, you just took all my money out of my safe, stuffed it in your coat pocket. Well, the rest of it says, you had my permission and you had a deposit slip and you were going to the bank. You don't have to do this. But if you want to do it, you can offer the rest of the evidence and that the judge determines in fairness ought to come in, okay? And that's an important distinction, right? It was always my practice. I very rarely played defendant statements in criminal cases, right? They're long, they're boring, and for, 3/4 of it, I didn't do it, I don't know what you're talking about, I wasn't there, you got this all wrong. Okay, it was me. Right, that's how they operate. 6 hours later, right? It was me. So usually I would just call the officer. Did you interview him? Yeah. What did he say? It was me. Right? Okay, I'm done. Or I would get the evidence, have them authenticate the statement. Okay, so the statement would come in, it would be admissible. and I just wouldn't play it. The jury would have it. If they wanted to listen to it, they could. Okay. Oftentimes, when I would do that, the defense would say, well, we want them to hear the whole thing. Okay. All right. And then we would sit back and we'd push play and we'd sit there, sometimes for 2 days, right? Because in a court, you're really not in session for 8 hours, right? On any given day. So 2 days later, who's the jury pissed off about? You know, they're not mad at me, they're mad at the defense attorney. They just made them sit there for 2 hours and listen to this. And then as soon as we finished playing it, I said, so officer, what did he say again? It was me. Right? So just re-emphasize it. Don't be mad at me, jury. I didn't make you sit through this. So the defense did. Okay. So that's a type of thing, right? If you're offering part of a statement and the whole statement gives it more context or more meaning, and it would only be fair that the jury hears all of it, the court can order that be played right then. If you don't want to, you can still wait and play it in your case in chief or give the rest of the writing. You don't have to do it right then. If you want to, you can. It's an option you have.
But the idea is, if you have the right to offer the rest of it, you know, the response to a letter or whatever, then the jury gets the picture of the whole statement or what really happened and doesn't have to wait for a week or 2 weeks or whatever. Because then it's like, well, remember when the people like offered this statement? Well, now we'd like to play the rest of the statement that explains that, you know, what. I remember that? I think I remember that, you know. So, but it gives not the proponent of the initial statement, but the other side the right to say, I'm going to interrupt their presentation of evidence right now, and let's hear the rest of the statement. Let's hear the response to the letter. Let's hear see another document that helps you do it. California state law is a little more specific on exactly what you can introduce. For example, if the letter's introduced, the reply can be introduced, things like that. But the concept is
Something to think about before you just willy-nilly say, I want it introduced. You know, or is it moving your case forward? Is it helping you? Okay. I was never afraid because I never would mischaracterize what the defendant said, but I just wouldn't play it. I would get the parts that are helpful to me and ask my officer about them, and he would testify to it, and I would call it a day. Okay. If the defense wanted to play the rest of the statement and get it in. Okay. And usually what has happened as well, which is at least in criminal law, was something that could be prohibited, is they hadn't prepared the statement. Okay, if I'm going to offer a statement into evidence, okay, I have to make sure that it's appropriately redacted, that the transcript is redacted. If this guy's talking about on his statement all of his denials, but he's admitting that he's a gangbanger, or he's admitting that he's a drug addict, or he's admitting, yeah, I committed that other robbery, but I didn't commit this robbery. That's all not admissible, right? That's not stuff you could use in your case in chief, right? So if you think that, hey, I might want to play this before you get to trial, you better have done the work to redact it, right? Because if I call my cop and say, what did he say? He said, well, it was me, I did it. Okay, and the defense says, well, I want to play all of it. All of it? Have you redacted it? No. You sure you want all of it? Right? And sometimes they do. And sometimes they play it, and the jury hears a lot of bad stuff about their client that they probably hadn't really thought about. Okay. If you're going to play a statement, you better know everything that's in it and make sure that you really want everything in it. Okay, because some of that stuff wouldn't have been admissible otherwise. But if you offer it and you don't, you know, there's not much you can do to complain about at that point.
So one thing you should note is it's a writing or a recorded statement. It's not a conversation. So don't try to use Rule 106 to get in part of a conversation.
Okay.
The rule is specifically limited to recorded statements and writings.
So for our purposes moving forward, 104, we're gonna know. 105, limiting instructions, we're gonna know. And 106, right, this rule of completeness of statements and recordings, we're gonna wanna know. Okay, and you don't have to get the rule down word for word, just know the concept such that you can articulate it back in test format. Okay, we got to know that you know the rule, and if you don't write the rule down right, then your analysis probably isn't going to be right. Okay, if you write down the rule for 105 that the court makes a determination that certain evidence is going to be admissible for a limited purpose, I would ask the court to give a limiting instruction. Okay, but if you don't say that, well, you know, the rule 105 says that the court can admit evidence for a limited purpose. You leave the second part about asking for a limiting instruction, and then you analyze it. Your analysis, you may never even mention that the court could give a limiting instruction to the jury, right? But if your rule statement is clean, your analysis is really easy. Okay, you just throw the facts into what your rule statement is. So the key is understanding it from your point of view, understanding what the rule is actually saying and what's the purpose and policies underlying it. Then it's easy to analyze. Okay, so 104, 105, 106 are definitely on your to know, expect questions on the midterms, on your finals, discussing those. All right. So we've talked about, last week we talked about trials and evidence and the roles that the different parties play. We want to get into that a little more in depth now. Okay, the readings were the same. It was still chapter 1 and chapter 2, right? Chapter 1 kind of gives you this introduction to evidence, and chapter 2 talks about the different respective rules for everything. So one of the things that we need you to make sure that you understand is what exactly evidence is and how it is that you examine it. Okay, how is it that you analyze the facts? Okay. Evidence, generally speaking, right? There's other specific descriptors, but generally speaking, evidence is testimony from the witness or an item. Okay? Testimony from a witness or an item. Sometimes the testimony from the witness doesn't necessarily make sense. Right? There's in chapter 1, there's one transcript that it says, "Who's Jimmy?" That was the attorney's question. Attorney's questions are not evidence, except to the extent that they help you understand what the witness answer is. Who's Jimmy? Well, that's not evidence. That's an attorney's question. Well, the answer in the transcript was, he used to work at Bill's. Well, if only that is the evidence, he used to work at Bill's, how does that tell us? Who used to work at Bill's? Right? The attorney's question now becomes part of the evidence because it allows the answer to make sense, right? Jimmy used to work at Bell's. Okay, so you need to keep that in mind, that as a general rule, questions are not evidence except to the extent they make the answer relevant and informative. Okay, if the answer speaks for itself, then the question's not evidence. All right, you guys, does that make sense? So that being said, evidence is testimony of a witness or an item. How do you object to evidence? You object to evidence one question at a time, one answer at a time, or one item at a time. Okay. If a question is objectionable, you object to the question. That is what makes a timely objection. On its face, right? What did Jimmy say? Sure sounds like you're about to ask for some hearsay. We don't know what Jimmy said, so maybe we don't know if it's hearsay yet, but sounds like you're asking for an out-of-court statement, right? Maybe you object to the question. Okay? Maybe it's not until the answer, right? Maybe the question was, how do you know? Well, Jimmy told me. Objection, right? Now the answer is what is giving you the rise to object. I'd like to offer this picture. I don't want to offer this shoe. I don't want to offer this water bottle. Objection, right? You object one question at a time, one answer at a time, one item at a time. Okay? That's how you need to analyze this. So, what makes you a good lawyer in court? Listening. Listening. Right? If you're not paying attention to what the other side is doing, how do you know whether to object or not? If you're not listening to every question they ask, every answer the witness is giving, every piece of evidence they're trying to enter, how are you doing a good job protecting your client's rights, protecting the record, so you can preserve your claims of error if there are any? You're not. And you will see people do that all the time. They will call a witness, they will ask all their questions of that witness, and then they'll sit down and the other side will be asking, and they'll be talking to the person at counsel table with them, or they'll be looking at their notes, and they're just not paying attention. Okay? You're not protecting your client's rights by doing that. Okay? And if you're the one directing your witness, you've got to know, here's the questions I'm going to ask, such that they're not objectionable. Here's the answers I'm expecting to get. And to the extent they might be objectionable, this person's going to tell me, well, Jimmy told me. Well, I've already thought that through. I'm anticipating an objection, and I know what exception applies to let me get over that. And if I'm offering an item, I know which witness is going to be able to lay the foundation for that. I'm going to know what that foundation is before I try to introduce that item. Basic stuff, common sense stuff, right? If you're trying to present your case, you've got to think about all this stuff ahead of time. In real life, a lot of attorneys don't. They go in and they wing it. And you see this little circus, right? They try to do something. Objection, sustained. They look at the judge. We're attacking you. And they'll ask the same question. Objection, sustained. But Your Honor, this is a big deal. This is an important piece. Okay. I hear you. still sustained. And they have no idea what's going on. They have no idea, why they can't get it in, because they hadn't put thought in ahead of time. They just figured, oh, it's a picture. Pictures aren't admissible. And maybe the picture is admissible. Maybe it's not just admissible with this witness, or maybe it is admissible with this witness, but you haven't asked the question yet to lay the foundation, right? So doing that homework on the front end to make sure you're able to present all the testimony and all the items that you want, and then paying attention to what the other side is trying to do, that's how you protect your case and preserve your claims of error. Anything short of that, you're missing the ball. Okay? You can't just sit back and let the other side do whatever they want. So, let's look at problem 1-2 on page 6 there. Now this is a class that we love participation. We love volunteers. We make sure there's always enough to go around for everybody, but if we don't get any volunteers, you know where we start, guys. Daniel, you're up.
I'm gonna read it aloud.
Yeah, sure. Yeah.
Inspector Quasso investigates the scene of the gruesome murder. He finds, among other things, 1, a blueprint of the building in which the murder occurred. 2, one of the victim's earrings lying on the ground near the victim's body. 3, a paintbrush spattered with blood. 4, a photograph of the scene without the body in it. 5, a Saturday Night Special handgun lying under a nearby bed. The inspector then interviews 3 people who are standing in the area. One of the 3, a neighbor who knew the murder victim. The neighbor, Bill, tells Quasso, that the victim was Jane Duplain and that she was having a torrid affair with Bill's best friend. During the interview, Quasso observes the maid furtively placing an object in her pocket and a young man running away with what appeared to be an earring in his hand. Which of Quasso's findings or interviews constitutes proof of the crime? What rules of evidence might apply to that proof? What proof might the jury be allowed to take back with them to a jury room? Why?
Let's just go through each of them,
Okay. So
right? One at a time. So blueprint of the building where the murder occurred. Think that's admissible?
No.
Why not?
Because it's not relevant in. See, I don't even know which rule I'm supposed to be.
Well, and right now we haven't given you any rules, so we want you to just kind of think on your feet. Can you think of a reason why you might want to use a blueprint in a murder case?
In regards to the paragraph afterwards, no, I don't think so, no.
Okay, do you think the layout of the building might be important if you're trying to describe where the body was, in comparison with other rooms, maybe how the murderer might have gotten in or out without being observed or noticed, right? Those are the types of things why that might be relevant.
Yes.
Okay, at this point, we haven't given you the facts to support that, but common sense would tell you there's maybe a reason why we might want that, the blueprints. If you did want the blueprints in, right, this is your case, you're the murder prosecutor, how do you get blueprints in? Without a rule, what do you think?
Show how it's relevant.
Well, you're gonna have to show how it's relevant, okay, but you're also gonna need to do what?
Prove that the body was in the building, but I'm trying
We're talking about blueprints. What would you need to do to get the blueprints in?
ask to get them in.
Okay, well, you're gonna have to, right, we talked a little bit about foundation. That's what we want you guys to talk about. This is an item, right? If you wanna get an item in, you're gonna need to show how it's relevant. And you're gonna need to show that it is what you say it is. Okay, so somebody's gonna have to come to court to testify, right? If I say, hey, you recognize this? Yeah, what is that? It's a bottle of water. Well, you know there was a bottle of water at the crime scene, right? Yeah. Is this that bottle? I don't know. Right, I saw a bottle of water and I walked away. I don't know if that's the same bottle or not. If you don't know that, you're not the witness to get the bottle of water in. Does that make sense? I need somebody who can say, I went to the scene, I saw a bottle of water, I picked it up, I put it in a bag, I taped it, I sealed it, I signed it, and I opened the bag here in court. That's the bottle of water I picked up, right? So you need somebody who can testify that the item you're trying to introduce is what you say it is. So if you want blueprints in, somebody's gonna have to come and say
Testify that they know that
that these are blueprints. And who might do that? Maybe a city engineer, maybe a building manager, right? Something like that. Lay witness, a cop probably isn't gonna have the knowledge or training to say, yeah, these are the blueprints of that building. But if you did want the blueprints in, you're gonna need a witness who can come in and say, those are the blueprints for that building. Make sense?
Yeah.
Now, down below, you got any witnesses down there who can give you that?
No.
Okay. But does everybody understand blueprints are just an item? And we'll get to relevance, but it's an item. And if you want it in, somebody needs to be able to come in and say, that is what we say it is. And you, as a lawyer, need to figure out why it's relevant. Your witnesses don't figure out why it's relevant. You figure out why it's relevant. Now, this is relevant because, as you can see on the blueprint, there was a fire escape over here. There was a balcony to the side, right? There was a front door. This had multiple.
And then you lead the jury to that conclusion why it's
Right.
relevant.
Well, then you would tell the court why it was relevant, why it should come in. Then once it's admissible, that's something you argue to them. Here's why I offer the blueprints and the evidence for this reason.
Simply way of saying, here's why it matters.
Okay, so since we're talking evidence, evidence is testimony of a witness or an item. What if that blueprint has 10 pages? That one item or 10 items?
I think it depends if it's bound together or not.
Absolutely. Good to see. Yeah, it absolutely depends if it's bound together. If that is one thing taken together and is bound together, it's one item. If it's, well, hey, this is the floor plan, right? And this is a heating layout, and these 2 pages deal with the electrical system, right? Well, maybe you've got multiple items there. But if you're just talking about a single item that's bound together, it's multiple pages, it's one item. If it's made up of multiple things, maybe you need to break it apart and have multiple items. Make sense? Okay.
So for one of the victims here, it's lying on the ground near the victim's body. And you have to have a witness testify that this was an area of the victim. to the victim?
Well, somebody's gonna come in and say, I found an earring on the ground, right? Probably a crime scene crime scene investigator who's processing it. Gonna say, I found this. And maybe you tie it to the victim some other way. Maybe like OJ, you got a picture of the victim wearing these earrings, right? But for this purpose, let's assume it's not the victim's earring, but it's just an earring that was found at the scene. Can I come in? Right? It's part of the crime scene. It's there. It's evidence of something. What would it be evidence of?
Another person was there.
Right? Maybe another person is there. Right? Maybe evidence that it was female perpetrator as opposed to a male perpetrator.
Or someone who identifies as
True.
or at least someone who wears earrings.
So, right? And what about down below? You got any evidence that you think might
The maid put something in her pocket, or the guy running away, what appeared to be here. So you then call them as a witness.
Clouseau is your witness, right? Can a witness testify to what they see?
I think so.
Sure, a witness can testify to anything they perceive. They see, they hear, they smell, they feel, right? Anything that they perceive. They're allowed to testify to their perceptions, subject to the rules.
So Clouseau is the witness.
Clouseau is the one who observed the maid do it.
Okay.
Okay?
So I just read that he was the investigator, so I didn't think I thought it would be one of these people, whether it be the maid or a guy running, but they would be called as a witness. Not Clouseau.
So Clouseau takes a stand, and what did you see? I saw the maid acted furtively, and she placed something, some object in a pocket. You know what it was? Apparently he doesn't, but facts don't give you that. Another important point for your tests, don't assume facts. Use the facts that we give you. If something's missing for the analysis, say that. But don't just assume and make up something that's not there. Okay? Clouseau can say that, right? Nothing wrong with that. Suspicious. Does it move your case forward? Is it relevant? I don't know. Right? How else is the maid tied in here? Right? We don't know that yet, but him testifying to what he observes, not necessarily problematic. Testifying to the young man running away, sure. You see the young guy, what do you see? I'm running away. You have anything in his hand? Yeah. What? It appeared to be an earring. Can you describe it? I mean, that's where you're going to get into your issues. Is how do you know it's an earring? It looked like what we found on the floor. Okay. Right?
So the photograph of the scene of the body unit. You have a witness testify that the photograph was of the scene.
I was there. That's what it looked like.
And pretty much anybody can lay a foundation for a scene.
You didn't take the photograph, did you?
If they're familiar with the scene.
Yeah, you didn't take the photograph. How can you know it's not a
You
fake
think you didn't
photograph?
take the photograph?
Yeah, all you have to do is say, yep, I saw it. That photograph looks like what I saw.
And so I'm still confused about Clouseau or maid. Like, when you have the maid then testify, Because she would know and be more familiar with the scene than the investigator was, just because he was there.
Good.
Good, but yeah, it's, at this point, with what you know of those facts, you think the mate's gonna wanna come in and testify? Anyways, they're gonna start pointing the finger at me. I'm not gonna, you know. But sure, the maid, and it could be anybody who can say, yeah, I see this photograph, that's what it looked like that night. That's all you need. It could be the first cop who arrived on the scene, it could be a maid, any maid who came in afterwards, that's familiar with the room and building. You can say, yeah, that's what it looks like. So.
Okay, and a Saturday night special handgun lying under a nearby bed. So could you bring a witness then, the person who then found the gun?
Sure.
I don't really understand what Saturday night special has anything to do.
It's a description of the guy.
And that's gonna be your argument. Do you know how our victim died? Yeah, facts don't tell you. So is that gun relevant?
Maybe.
Maybe not.
The victim died was stabbed one, the gun probably had.
So you know you're gonna want to have those. So that's a situation where if you were to get this question on a test, and we were to ask you, is this Saturday night special relevant and admissible? And that's the only question. We would need additional facts to make that determination. Assuming the victim was shot, then yes, clearly the handgun found at the scene would be relevant. If the victim wasn't shot, maybe it's not. So.
But couldn't, I mean, it's still gonna have fingerprints on it of the suspect, so
Sure.
even if he died of stab wound, or she died of stab wound.
But
still
that's
have fingerprints on
right.
the gun.
But that's what you want to be careful of, right?
Ah.
You don't want to assume facts that aren't there. If you know that the gun has fingerprints and you've tied those fingerprints to your murder defendant, and right, you've clearly got other evidence that directs you to a certain person. Well, then yeah, clearly it's relevant. Why is it relevant? It's got the defendant's fingerprints on it. If the facts don't give you that, don't go down that rabbit hole on your own.
Don't be making it up.
Right? Unless you need to know, unless you need more information to make the determination, articulate what is it that is missing, right? What's missing here is we don't know if the gun is relevant or not, right? Was the victim shot? Was he stabbed? Are there fingerprints on the gun, right? Those are fingerprints, are they tied to anybody?
Ooh, maybe it was the victim's fingerprints on it.
Self-defense.
So maybe it was self-defense, yeah.
I mean, there's a lot of things that you don't know.
But you don't know anything about it, right?
So instead of giving both sides of assumed facts, you would then just.
Yeah, we don't know.
This is the
So.
yeah, the fact we don't know, so.
And what proof might the jury be allowed to take back with them to the jury room? Think the jury's gonna be able to take a blueprint?
Assume that it's introduced in evidence.
Yeah, assuming all this came in. Do they get the blueprints?
No.
Why not? It's a piece of evidence.
So any piece of evidence, any item.
Well, we're gonna go through it,
Let's do this one.
right? You think, you see any problem with the jury having the blueprints back there to look at, to see, and,
No, they should be able to.
Yeah.
okay? And earring,
Documents are usually not a problem.
and earring?
Why not?
Maybe there's no reason why not.
Yeah.
Right? What about a paintbrush splattered with blood?
Might be a little hazardous.
Right? And you're probably not gonna even open that up.
Yeah.
Okay? Right, that's gonna be sealed up and the judge probably
So
doesn't want
that's like
that.
my follow-up question, does it go back there sealed up where they're instructed to not?
Probably not.
Probably not.
So what do you send back instead of the paintbrush?
Picture.
A picture of it.
Okay.
Gun, we're sending anybody sending the gun to the jury room. Okay, So here's my favorite example of what somebody wanted to send to a jury room that I ain't ever sent it to a jury room. In one of my early trials as a judge, it was a bank robbery, and in the vehicle, the getaway car, they found, among other things, a half-drunk bottle of Jack Daniels, half-empty bottle of Jack Daniels. And one of the defendants wanted to argue, I couldn't form the specific intent to do the robbery to help a gang because I was drunk. And that person's lawyer wanted to send a bottle of Jack Daniels into the jury room. Did I send a bottle of Jack into the jury room? No. You want to take a picture of the bottle of Jack? Go ahead. But we're not sending liquor into the jury room. Good try.
And on that note, great time.
Yeah. That was so funny. It was Ari Bender. You ever deal with him? He was a character. I'm like, no. You're not sending Dr. Jack in the jury room.
I still remember this one time I had this case where we had found out in the wild this vehicle had like something like 30 kilos in gasoline. Gas. Right. It was really a neat case in that he ran out of gas. He left the car on the freeway. Car ended up getting impounded. While it was impounded, the CHP took his canine, drug sniffing canine, to the impound to test.
Right.
Not
because they suspect that car.
He was practicing. He went out and planted.
And the dog reacts to the
The
car.
dog reacted.
Like, huh.
They got
I wonder why he's reacting to that.
And then on Monday, this guy shows up. Hey, that's my car.
Really? I'd like to talk to you for a minute.
And I thought, you know what I'm going to do? I'm going to be very dramatic.
Yeah.
And I'm going to bring every one of these bricks in. I'm going to stack them up in front of the jury. And somebody from the sheriff's department said, called my supervisor. And said, do you know what this idiot of yours is trying to do? You know what manpower we would have to
Take that much.
to take that and guard it
Yeah.
in court,
Yeah.
and then what's he gonna do with it? The court's not gonna take that into evidence and take a picture of it.
Oh, come on, the picture's not dramatic.
Paul Byron was my supervisor, and he was not having it. Come on,
That's pretty fun.
you know better than that.
That's pretty fun.
Oh no, it's a link again. You can't open it? Is that right?
I can't open it.
Yeah, let me try to share with you then and see what happens. Did Veronica not like approve or share with you?
No,
No.
because it needs a code.
You gave me Google Drive.
So I wonder, should I ask Veronica?
Yeah, you might have to, but yeah, that's why if you would get like if you had a flash drive, just give it to you so you can download it yourself.
Okay.
Because I don't have flash drive.
So what I'll do is I'll just bring a flash drive on Saturday. I'll get it done. I have one, but I have other stuff on it, contracts and all that other junk. So I'll get it.
Okay.
Okay, so I'll do that on Saturday.
I don't know, good too.
Okay.
I thought we were sharing it all on Saturday. I think you left early, did you?
I left a little bit, you guys are still working on it, and then I
Didn't we?
left,
Yes, you
yeah,
did.
because you guys,
Then I didn't pass it around. Let's see.
oh, okay.
Weird. How's your study going? Are you consistent?
Kind of consistent, I feel like he's explaining.
How's it going?
Pretty good. Be better. How's your weekend?
All right. A memorial service to go to, and the place was not big enough, so the room was really hot and packed.
What was that at?
Riverside,
Oh,
Riverside Art Museum. Obviously not a religious person.
Yeah.
Right, you're doing your memorial service at an art museum? You're not really.
No traditional, is it? I'm starting your civil procedure.
That's civil procedure, I was doing, real property.
Oh, yeah. Just like the cases level. Still
It's funny, I
like
don't know why.
I mean, I can't wait till you get to like moderate. We're
Um,
like so deep into like constitution.
For
I
some
think the
reason I
majority
like
is
it.
right. Which cases do you like? The gay one's pretty funny. The great onyx one, the first one.
No, there was,
I love the great onyx one.
is it the last one? It was not the
That's
law of
the-
discrimination,
Yeah,
but it was handed down from,
yeah, he,
the ones that were handed down.
yeah. He,
So it was pretty more, it's more of civil, you know, can they, and this was,
can they, post judgment or on that, agreement.
yeah, and it had to do with civil rights and stuff like that, you know, they have the right to be part of that, but it was like, it's, and this even, it talked about their ancestors owned it even prior to.
Oh, you're talking about the Native Americans?
The Native
Yeah,
American
like,
ones,
wait a minute,
yeah,
like,
the Native American.
yeah, oh,
ones.
yeah, that was just,
That one
that was
was,
messed up.
yeah, that's the one I like, cause I was like,
Yeah, I was like, dang, he just inherited everything. He's like, here, let me take that back.
I know, but I said, and a lot of it has to do with, cause the king of England just said, take it.
Yeah,
You
there,
either, you know, you fight for it or you buy it, it's one of the two.
yeah, and then when then after the crown left, it's like, they're taking all back, and then the guy's like,
Yeah, so it's kind of like, so now you had to argue it, and then it was never argued before.
Yeah.
So it's like, okay. So I just found it interesting.
Yeah.
The gay one, was that the one in Texas?
Which one? You only have 3 cases, right? You only have 3 cases. The one-
Yeah, but I still have to write out the ones from last week.
Oh, okay.
I haven't written those ones out.
So have you done the new ones?
Huh?
Have you done the new ones yet?
Yeah, I read everything, I just haven't written them. So
Johnson Macintosh was,
I have to write them out. So
Yeah.
that's what I was gonna do tonight, but it's gonna be, by the time I get home, are we gonna be here till 9:30?
let's see,
I thought
we still
they
gotta
said-
go through the problems.
I know, but I thought they were saying that didn't he say last time that they were told that we have to stay here the whole time?
At least until 8:30.
Oh, till 8:30?
If before 8:30, I'm not too sure, because this friend thought he did before 8:30 or something.
Oh, okay. Because if we do that at 8:30, or even 9, but I thought if I do that at 9:30, I won't get home till almost 8:30. No, it just takes that long to get home.
You?
It takes me an hour and 10, 15 minutes.
Okay, yeah, makes sense.
Yeah.
What do you have going on in the car? You have photos?
No.
Come on.
No.
You got it. I
It
downloaded,
irritates me after a
I
while.
downloaded the player and I'm able to speed up
Oh.
playback. So I put it to times the speed, and it's remarkable how your mind like adapts to that speed. I'm like, and then when I go back to regular speed, it's slow as heck.
It
It's
drives me nuts.
to me, it's like if you're driving like 10 miles per hour when I go back.
I don't even listen to it. I just like hear it going, oh, wow, wow. It's, oh my God. Because I can't do that. There's no way.
I had to. It's like my gives me sense of security, I guess you could say. Because if I'm like
That's not my security
No?
right there, no.
because for me, if I'm like if I do the examination, it's like if I can hear a voice, it's not my voice, it's something else. It's always an outside voice. I'm like, oh yeah. That's
No,
my
I
strategy.
I used to, I have to have music.
You
Because I have to have that.
what do you play like the jazz music?
No.
No?
I do all the classic. What is it, they call it classic?
Classic.
That's very my kind.
Yeah.
All right, we're all back. So, right, we looked at 1-2, you kind of saw a little bit of the examples of what was going on. Hopefully you saw some opportunities as to how you would address it, right? If the other side's trying to get something in, right, you're going to be objecting. We've already talked about that, right? The way they're going to get it in is there's going to be some rule that applies, right? The rule is going to apply to either the item or it's going to apply to the type of testimony that you're seeking to elicit. Okay, so you need to know the rules that let you elicit that type of testimony or introduce that item, and the other side is going to seek to knock it out. Right? They're going to seek to not allow you to do that. So you're going to object at the time of the question, at the time of the answer, at the time you're offering the evidence, the item, and they're going to give their specific objection. And the best objections are going to be those that state the basis, relevance, lack of foundation, right? Hearsay. I know we haven't got there, but hearsay, what have you. And your response will be, the foundation for this item is X. This witness testified to that. We believe we've laid the proper foundation, right? Or this isn't a statement being offered for the truth. It's not hearsay, right? So there's this game that goes on where you try to get stuff in, the other side tries to keep it out, and like the only real way to do that in a meaningful way that preserves the record is to use that sort of specificity. Now, what commonly happens is somebody will object. They won't give a reason. Sometimes the court will ask, well, what's the basis of the objection? Sometimes they won't. Sometimes the court will just rule. Sometimes the court will ask you to respond, and the other side will respond, and it's like, but what if that wasn't their objection, right? Sometimes the objection's obvious, from the context of when it's made. If it's not obvious, good luck, right? The appellate court's not going to second guess anything. They're not going to fill in the blanks for anybody. So as we go through this, keep that in mind. So let's take we had a couple of problems that we were working on, right? So why don't we jump to chapter 2, right? Chapter 2 is talking about the roles of the judges, the roles of the jury, the roles of the attorneys, their trial, and they talk about some examples of how each of those roles plays out. We went through this last time, so there's not much of a need to beat that dead horse. Like the attorney's role is to present their case and make sure that the other side is playing by the rules by way of holding them accountable through their objections and whatnot. And the court's job is to ensure that both sides get a fair trial, right? And that the law is followed. And so with that in mind, why don't we take a look at problems 2-1.
I wrote an answer for that,
Okay.
and I don't remember why I wrote it. So
Let's go through it. Let's take a look at it.
So Al sues his ex-wife Anne for increased alimony payments. Anne seeks to introduce at trial a journal that Al regularly kept of his expenses. Al objects, claiming that the book is a fake. Al submits a letter from a person who claims to have written a journal in exchange for a $4,000 payment from Anne. Can the judge consider the letter from the purported author of the journal in determining whether to admit the book and why? I reason that the letter may be admitted. based on
The letter may be admitted or may be considered.
maybe consider.
Right.
And then, well, based on conditional relevance,
Okay, well, first of all, what type of hearing are we holding?
a preliminary hearing.
Yeah, under which rule?
Rule 104.
Right. And so do the rules of evidence apply at Rule 104? At a 104 hearing?
They do.
No. So what does that mean? You don't have to call the dude that wrote this letter that said that he forged the book, right? Go ahead.
So am I right on the conditional relevance language I'm talking about here?
Well, I was getting at, you don't have to worry about the rules of evidence, so you can introduce a hearsay statement like that.
Okay. And my reasoning is to determine if the journal was based on false or created on false means or actually actual expenses that he kept. So that's my reasoning on that one.
Okay, well, there's really two issues that are raised right here. Okay, the first one is based on the rules, right? Can the judge consider it? Right, we already said yes, right? Because the rules of evidence don't apply.
If the rules of evidence did apply,
What was the objection? Right, what does the question say?
it's a letter from some guy.
So
So it's not some witness testifying on the hearing.
it's a hearsay evidence.
So, well, that's not what Al says, right? Al objects. That book is a fake. That a legal objection? Right, what have we asked you guys to do? Right, when you object, point to the rule, use specificity. Factual arguments are not objections, right? You've got to have a reason that you're objecting.
So
There's
what
gotta
would
be
the
a
what would the
rule of
objections? So what would the objection here be? That document hasn't properly been authenticated. We don't have enough evidence to show that it is what they say it is.
You see that?
Yeah.
You see the difference there? So from a procedural standpoint, that's not a good objection.
That it's a fake.
It's a fake. Okay? Objection. What's your basis? It's a fake. That's not an objection.
So you got to kind of twist that around and say
So-
what it is.
Look at that, and when you're looking at these things, keep that in mind, right? Is that a grounds for objecting? Probably. But what is the legal basis? If something's fake, it's not what the other side is saying it is, right? What objections can you raise, for that situation, right? Maybe they haven't laid a foundation, they haven't authenticated it, they haven't done a number of things. Maybe it's a credibility issue, right? Maybe Anne has laid the proper foundation. Maybe she has authenticated. She says, you know what? I've seen this journal.
I recognize that handwriting.
I recognize it. I've seen it writing it, and on some of these pages, that's my writing. And if all he's saying is it's a fake, that's not an objection. That's okay. You get to take the stand and you get to tell the jury it's a fake.
So now she has purported at least to authenticate what that document is. Right? But there's some more evidence. What else have we got? The letter from the dude who says he faked it.
Can the judge consider it? Right, it's a 104 hearing.
Is there anything that prohibits the judge from considering that? Anybody?
So
No, there isn't.
Now, that being said, I think you'd be hard pressed to find a judge that would rule just based on a letter without the person there, right? If one side is saying this is this, I recognize it, I'm authenticating it, I'm laying a proper foundation, this should be admissible, and the other side saying, it's a fake, I've got a letter. Okay, is that person gonna come and testify? Nope, I just got a letter.
How about if you've got declaration, signed under penalty of perjury, and it's got some details that says, I met wife on such and such, and she gave me a check. Why would you pay a forgery with a check? But she gave me a check for $2,000. And see, here on the subject line, it says, fake book for Al. And then when I gave her the book, she gave me another check for another $2,000. So I forgot the number. Whatever. Anyway, now what do you think? Well, it's looking a little more like just maybe you're going to, the wife's going to have a hard time getting that in. But the point is, you can consider out of court statements, right? You can consider the letter or another statement. You can consider the canceled check that the dude like kept a copy of when he canceled the I would like to do that. But anyway.
No, those are the types of things you want to be on the lookout for, right? The rules don't apply. That being said, keep an eye out, right? What's the basis for their objection? What are they actually claiming? Because if you don't understand what they're arguing, how are you going to respond to court? Right? That goes a long way. For you giving an informed, intelligent response is knowing what the heck the other side is objecting to. And just because the court can consider it, don't jump to that next step, right? You might be saying in your gut, well, I think, this journal is admissible. So no, the judge shouldn't consider that because that's not fair and this should be admissible. Right? But that's not the question. The question's not asking, should the journal be admissible? It's asking, can the judge consider it? Yes. Why? Because he can consider anything. This is a 104 hearing. Okay? So don't get wrapped up in thinking you know the admissibility answer and answering the consideration question with what you think the answer should be and whether it comes in or not.
Call the question is really important.
So, how about number 2?
So Anne calls Al's new wife, Christine, to the witness stand. Al objects relying on the marital communications privilege. What standard of admissibility applies in determining whether the privilege exists? How does the standard compare to general relevancy determinations?
Okay, so what do we know about the rule about privilege in a 104 hearing? It does apply. That's the one evidentiary rule that you got to follow, right? So you got to figure if there's the spousal privilege. We're not going to worry about the details of what the spousal privilege is, but if the spousal privilege applies, then what? So who's trying to call whom?
Anne calls Al's new
So ex-wife is calling current wife, right? So if the privilege applies, does ex-wife get to call current wife? No, because the privilege applies. Yeah. So how is that different from what's the question?
What the standard of admissibility applies in determining whether privilege exists?
Okay. And so how would you answer that?
So she's able to call Christine to understand because no, she's not able to.
Can't do it. So what's the standard? Is there a privilege?
Yes, there is.
And what's the next part of the question?
How does the standard compare to general relevancy determinations?
General relevancy determination, the rules don't apply, right? The privilege is the exception to the rule. The rule doesn't apply, if there's an exception, one rule does apply.
That's perfect. And what is the burden of proof required in a 104 hearing?
Beyond a reasonable doubt, anybody?
Preponderance of evidence.
Right? That's right on the page right before it talks about questions of admissibility. In a 104 hearing, it doesn't matter what your burden of proof is in your case. The burden of proof in a preliminary question hearing is honor to the end. Okay?
So, in a criminal case, right, yeah, that's really important.
Know that you will get a question potentially somewhere down the line asking you about the burden of proof.
So, in a criminal case, right, the prosecution wants to offer a piece of evidence. It's challenged by the defense. Does the prosecution have to prove beyond a reasonable doubt that preliminary fact to get that piece of evidence in? No. The standard is preponderance of the evidence. More likely than not that that preliminary fact is true. Okay? So there, the people don't have the burden of proving that preliminary fact beyond a reasonable doubt. But some criminal defense lawyer is probably arguing tomorrow morning in some court somewhere that they do.
Questions on the alimony out? Right, these are, we know at this point, you guys don't know any rules, but we want you to start thinking about what we have covered up till this point, okay? And what we've covered up to this point is 101 to 106, and how you go about objecting and responding to your objections, okay? And on the page before, on page 32, it talked about what the burden of proof is on in a 104, right? So keep that in mind. Who wants to jump into 2-2?
I'll do it.
All right.
Justice was done, so appeal immediately. Rebecca is tried on charges of robbing a grocery store. In her defense, Rebecca offers to testify that she exchanged blows with the grocery store manager more than 1 year prior to the alleged robbery and had not been in the store since that time. The prosecution objects, claiming the evidence is irrelevant. The trial judge improperly sustains the objection, ruling that no mention of the altercation would be allowed. Rebecca is convicted. She appeals the conviction, claiming the exclusion of the evidence was an error. What is the appropriate standard of review by the appellate court? Said it was evidentiary error.
Okay, well, what does that? What does that mean?
Oh, well, because the trial judge improperly sustained the objection, that's that 105. Part 104. Part 104.
Hold on. At this point, what is the question asking? Don't think too hard. What's it asking you? What is the appropriate standard of review by the appellate court? Okay? Have we talked about any rule tonight that tells us anything about appellate court standards of review?
I thought it was in 104.
We haven't.
Oh.
Right? There's nothing there. So where are the appellate court standards of review?
In the, B, under B.
One paragraph up,
Right.
right? There's 3 of them: abuse of discretion, de novo, plain error. What is the abuse of discretion?
evidentiary error? That's not the question you're asking them.
When is abuse of discretion used? When is that standard used? Not trying to trick you guys.
When
You
it's,
see it?
it's the parent of the record, then how. With concerning important evidence.
Okay, that's the plain error standard.
Oh, it's no longer review, it's when the issue is question of law.
Okay, this is new question of law, right?
I'll give you some discretion.
That means when a rule gives discretion to the trial judge and their ruling exceeded the boundaries of their discretion, right? So in this case, she wanted to talk about the fight before. Did the judge have discretion on that?
Yes, sir.
Sure he did.
I did.
Yeah, that's a 104 issue, right? Somebody's trying to introduce evidence, and who gets to make that call? The trial judge. Because the trial judge is the one that's considering what both parties are putting forth. If they need to hear testimony, they're the ones that are hearing the testimony. If they need to make a credibility determination, they're the ones that are going to make that credibility determination, right? Wait a second. Anna says that this is Al's journal. Al says, no, it's not, it's a fake. Oh, you just heard from both of them, make a call, right? That trial judge has the discretion to make that credibility determination based on everything they've seen, who they believe and who they don't, and what they're going to allow in and let in. If the appeal is based on something that involved the exercise of discretion by the court, you review it to see if that exercise of discretion was abused.
Most issues that end up going up on appeal are abuse of discretion. Whether to let something in or not, abuse of discretion. Whether to award attorney's fees or how much attorney's fees, abuse of discretion. Sometimes there are legal issues. If it is a legal issue, the Court of Appeal can figure out the law just as well as the trial judge. They think even better. And so they just do that from scratch. That's the number.
And the last one is plain error, right? We talked about plain error in 104, but we didn't talk about plain error on 104 with regards to the appellate court, right? We talked about it with regards to the trial court. Remember, if the trial court observes something is an error and it affects a substantial right, the trial court can intervene, whether the other side objects or not. Okay. The same thing, the appellate court can do the same thing. If it reviews that record, say this is a substantial right, is impacted by this plain error on its face, they would use the plain error standard in making that review. Okay. Why do we ask you these things now? You need to understand what goes on at the appellate court and the importance of making your record and protecting your record so that the appellate court can make a clean review of the case. Okay? It helps you if you know I'm trying to get this piece of evidence in. Okay? And the judge is ruling that I can't get it in. I know that that's a discretionary call on his part. So, how am I going to overturn that? It's got to be an abuse of that discretion. So maybe I start framing my arguments in such a way, okay, to try and demonstrate it. You never accuse the court of abusing their discretion, but maybe you start articulating, well, Your Honor, there are other cases that are factually similar and have gone up on appeal, and this type of evidence was admitted in them. People v. Smith, the court ruled this could come in, right? People v. Jones said this type of evidence could come in, right? Maybe you start laying those foundations for the court, and every case that you cite, what do you think the appellate court's gonna do? They're gonna look at those cases and say, well, yeah, that attorney was right. This evidence has been ruled admissible in the past. Where do you find that out? Go to your codes, right? Your best friend in legal research, if you haven't been told that from a practicing lawyer, I can tell you, I still do it to this day. If I have a rule, the very first place I go is to my annotated codes. Okay? Your annotated codes are right down at the bottom. It's going to be broken down into subsections, and it's going to have a list of cases that have addressed that code section. Okay? And there you go. Well, I want this to be admitted under, an opinion statute. I go to my opinion statute. I've got all this authority laid out that I'm prepared to bring to the court's attention if the court doesn't rule my way, right? The initial determination is a factual one, right? But maybe in your argument, you bring prior cases that are factually similar to try and prove your point as to why you think it should be admissible. Okay? And you can do that to, if you have an understanding of what, if you know what the appellate court's review standard is. If you don't know what it is, you just kind of wing it. Okay? You may or may not have questions about standards of review. Multi-states are great for these broad areas of questioning. So you may get a question like that. So don't be surprised. Okay, if you're familiar, there's only 3 of them. No. Okay. Our last problem here is 2-3.
All right.
Vinny, a new member of the board, was conducting his first trial, a murder defense of his cousin in a small, conservative southern town. In its case in chief, initial presentation of evidence, the prosecution offered evidence that the defendant had committed adultery on several occasions and had made contributions to animal rights groups. Vinny objects to the evidence, saying, "No way those things are admissible, Judge. The evidence is incompetent, immaterial, and irrelevant. And I object." The defendant was convicted and he appealed. Should the appellate court consider these objections and explain? Well, what I had wrote as my answer was probably not.
Shouldn't consider the objections?
Let's go through. What makes up a good objection? The first thing is,
Has to be timely.
has to be timely. Is this a timely objection?
We know? We don't know.
You don't know.
Right?
And it has to.
So let's assume that it actually was timely made before they offered the evidence of the adultery and those outrageous donations to animal rights groups. Okay, so let's say there was a timely objection.
State the basis.
Right? So did they do that?
No.
What did they say?
That it was incompetent, immaterial, and irrelevant.
Okay, so at least a couple of those, at least one of those sounds like a real objection, right? Irrelevant. Why is it relevant to a murder defense that the defendant had adultery? They committed adultery. From the facts they gave us, is that relevant at all? I mean, even if you said it might be relevant, because it's an act of moral turpitude or something, it might be relevant to the credibility of the defendant. We don't even know if the defendant testified, right? So at least irrelevant sounds like it might actually be a good objection. Okay.
So what do you think the problem is here? from the facts as written, it seems like the prosecution offered all of this evidence, right? And then the defense said, hey, no way those things are admissible, right? So it sounds like it's not timely. And what's the objection? Is it incompetent? Is it immaterial? Is it irrelevant? Is that a good objection? To say, oh, I'm just going to object to every possible objection out there and one of them works?
Hey, they're all specific.
Right? That's not helpful when you just throw all that out there, right? So the judge made a ruling, presumably that this came in, right? It doesn't say the judge said it came in, but it says the defendant was convicted and he appealed. So you're the appellate court. What was the judge ruling? Did the judge rule that this was competent evidence? Did he rule that it was material evidence? Did he rule that it was relevant evidence? You don't really know because there's no real specificity there.
It sounds sort of specific, but it's really not.
Do you see that? And a judge can very easily clear this up, right? And a counsel can very easily clear this up. If that's the objection, and the court could ask them, are you objecting on all three grounds, or is there a specific objection here? Okay. If the court asked me to respond, I would say, what's the basis of the objection? If they say all three, okay, well now I'm going to respond to all three. If they don't, how do you know what to respond to? You don't. How does the appellate court know what the ruling was? It doesn't. And I can tell you, it was very frustrating for me in the DA's office. It was very common. In the public defenders did this for a long time, and maybe they still do. They had a trial brief that they filed, and in their trial brief, they said, Your Honor, when I object, I'm objecting A, B, C, D, E, F, G, H, I, J, K, L, M. And all I got to do is say object, and I'm including all of them.
And did any judge let him get away with that?
No. Right? But I would see DAs that wouldn't even challenge that. Of course you're going to challenge that. So you need to tell me, if you just say objection, it could be any of these or all of these?
And I, the judge, am supposed to, or the DA, I'm supposed to figure out which one you actually mean this time?
But it was
You still
a
see
real
this?
tactic, and
You
it
still
was
see
something
this
that
once
was
in a
used.
while. And I'm like, no.
So I mean,
No,
it's-
you need to say you need to state the specific ground of your objection.
Okay, and I remember I was in trial with one, and she was a good lawyer. She was a good lawyer, but a little bit too smart for her own good. She thought she was onto something, and when she objected, she used to do that. She would read it. Oh, you're not going to grant me my objection ruling? Then I'm just going to read all of this.
This
And then
is
she
also not a specific objection.
And then she looked silly in front of the jury.
But if it's like that old adage in the military, right? If you defend everything, you don't defend anything. If you literally say every possible objection, you are not making a specific objection, right? You're just throwing everything at the wall. To make a specific objection, you have to actually make a specific objection. So.
Make sense? You understand? Questions on lawyer Vinny?
So just so I understand. So the appellate court cannot consider these objections because there's too many. It's not specific enough.
No, it's more than that. It's from what it looks like, it wasn't timely.
Right.
And it's not really specific. Irrelevant and competent and immaterial is the standard crazy kind of objection, right? It's not real objection. Although you do see it on TV once in a while. Which reminds me of a scene from Kentucky Fried Movie, which none of you have ever even heard of. And there's a scene in that where one lawyer is asking the witness about a shirt, And the other lawyer objects. The shirt is immaterial. Oh, that's a bad time. But then the lawyer asks the witness to come with him across the courtroom. And the other lawyer says, objection, counsel is leading the witness. Yes, it was a really bad scene, but it was kind of fun.
All right, you guys all got an outline? Okay, I hope you see, this is kind of the type of outline you should expect from us. Don't expect an outline that says, Rule 104, here's your rule statement. Rule 105, here's your rule statement. That's not the type
You get
that we give you, okay? But hopefully this makes some sense for you, okay? So let's just go through this real quick. Right, this is basic evidence procedure. You can take this, keep it, stick it in a trial binder. You can go to trial with this and it would be helpful, okay? The rules of evidence come from what? There are 4 sources and they are in orders of importance. The rules of evidence are number 1, common law and customary practice, number 2, statutes. Remember we talked about maybe it's a criminal statute, maybe it's a civil procedure statute, maybe there's some other statute that talks about the admissibility of things.
Yeah, believe it or not, in the Code of Civil Procedure, there are statutes that govern evidence.
And
Like
lastly,
that,
case law. Okay, case law is a fact-specific interpretation of a rules application. Okay, so if you've got similar facts, the case law can be helpful. But your main, strongest argument, there's a rule right on point here, Your Honor, and this rule says I get to use this. Period. Right? And if the other side says, oh, there's a case that says you can't, right? Well, that's a fact-driven analysis. Are the facts of that case that says you couldn't use the evidence in that case similar to the facts of your case? If they are, eeks. Right? If they're not, you distinguish it. Well, that was a ruling in that case, and here's why. Here's the facts in our case, and that's why Your Honor shouldn't follow that case authority.
And what might be a way to explain why that holding doesn't apply here? What's the reason for the rules that we're applying? So remember, Rule 101 talks about why we have these rules. So what's the policy behind the rule?
Okay. When do the rules apply? Bench trials, jury trials, motions, when you're required to prove something, summary judgment proceedings, change of venue, things like that. However, you should know, in practice, they're not as strictly as enforced, right? The more informal the setting, the less likely the judge is to enforce the rules.
Family law.
Jury trial?
Yeah, jury trial? Yeah.
They're going to enforce it.
Family law? Are you kidding me? They
Well,
don't know
that's
what the
not-
evidence code is?
Yeah. Okay. They do not apply to miscellaneous criminal proceedings like probation revocations. We saw that in 1101, right? They do not apply to depositions.
Except,
Right? You want to explain it?
sure, in a deposition, you don't have to make objections unless if you didn't make it at the time, it couldn't get fixed. Or if you made it at the time, it could get fixed. So privilege, absolutely, right? A privilege and instruct your witness not to answer, because once that cat is out of that bag, that you'll be blown. Objections to the form of a question, things that can get fixed on the spot. That's leading, right? That's compound. That's vague. Objections to admissibility don't have to be made, right? Objection, that question calls for hearsay. Who cares? It's not being offered into evidence now. They're just trying to gather evidence and they're going to present it later to the court. So if it's a privilege issue or it's something that can get fixed now, you got to make it now. If it's something that relates to admissibility or something that down the line, you don't have to make it until later.
Okay. And that's the last point on your outline, right? Rules of privilege always apply but they must be invoked to apply. And if you don't invoke it,
If you remain silent, guess what happens? You blow your privilege.
offer, items of evidence are offered one at a time, right? One question, one answer, one exhibit, right? That's the way you have to approach this, right? If there's a question asked and an answer given, question asked, and you say, Your Honor, I'd like to object to the 2 questions ago, it's not timely. It's too late. The jury's already heard it.
Or what could you do? I'd like to move to strike the answer. Okay? That still may be time.
So, you know, that's why you got to pay attention there in the moment. You got to be, you know, active in your role rather than just sitting back and listening. Oh, let's see what they have to offer. Okay. And I tell you to be active and pay attention and be ready to object. The reality is, you're also going to hear both of us tell you, don't be an objecting fool. But if you just sit there, every question that's asked, objection.
You cannot make every possible objection.
And even if they are,
You'll get killed.
like even if they are objectionable and you're right, you don't look good, the jury doesn't like it, you look like you're trying to hide stuff. So that being said, we're going to also tell you, be strategic in your choice of what you're objecting to.
My dad was a lawyer, and he said he knew an attorney who could do this. I couldn't do this. And that was that the lawyer would ask the other side's witness, the other client or whatever, a series of objectionable questions. And we get objection, sustain, objection, sustain, objection, sustain. And the witness is kind of like, that guy's a buffoon. And then he'd ask the killer question that wasn't objectionable. And the witness would totally get caught off guard. Now, could I do that? I don't think I could do that. But this guy was really good at that. But what's the point, right? Know how the game is played. It's a tactical thing. And if you could do that, it could be really effective because everybody's sort of laughing at the lawyer that keep asking the objectionable questions, and then it's gotcha.
And, you know, some of these things are just little games, right? There is some strategy and tactics that's involved there, right? If I know I'm going to get a piece of evidence in, right, I'm going to get it in. One of the things that I do is oftentimes I would just get short with my questions. Okay. And one of the worst objections that they could make, I would ask somebody like, hey, you know, and you recognize this picture right here, you recognize this picture of the house? And they would say, objection, lack of foundation. Do you think I'm not going to get this picture of the house in? Okay.
Well, you haven't shown us that the witness knows what the house is
Lack
like.
of foundation. Okay. Sit down. And then I'm going to take the slow boat to China. And I'm going to ask every question that I could to lay this foundation. And 2, 3, 4 minutes later,
What question do you get back to?
you recognize the picture of this house? And it's one of those things, and it's just something. What is a jury mad at me?
No.
They're not. They're looking at the defense. Really, why are you objecting to that?
Yeah.
Now, they could have objected, and I could have just laid a real simple foundation. A part of it is, I want to teach them a lesson too. Stop objecting. Right? If you're going to object, I'm going to make you pay because I've already done my homework and I know everything I want in, I can get in. And if I can't, I know that because the judge told me in a 104 hearing, right? I've already taken it to the court. The judge says, no, you can't use that. Okay. So everything else I'm using, I know I can get in. And if they're going to object, tip, strategy, whatever you call it, I have tactics that I would use to make sure that they paid for it and hopefully stopped objecting.
And again, it's, what's the, object to the stuff that really matters, right? Pick your fights.
Now, if this is a really important photograph, and hold them to the fire. Make sure they lay the foundation.
But sometimes you get an adversary who's not as experienced as Professor Nolan. And so, objection. Crap, I can't get the photograph in. And they move on to something else, right? Well, shoot, if you're gonna let me get away with that, I'm objecting everything, right? And then, and I have seen lawyers get very, very frustrated because they know they can get this evidence in, but they just don't know how. And then if you're really lucky, the judge will be like, hey, Mr. Witness, did you live in that house for 20 years? Do you know what it looks like? And by the way, it's really bad form to object to one of my questions. You could do it, absolutely, but that doesn't come across very well at all, because guess who's going to rule on your objection?
So objections, right? Items of evidence are objected one at a time. It's the responsibility of the opposing attorney to make the objection. Right? If no objection is made, evidence can be admitted, even if it's privileged, irrelevant, hearsay, opinion. That's just to make the point. Those are all objections. Right? It could be inadmissible on 4, 5, 6 different grounds, but if you offer it and the other side sits on their hands and says nothing, and the judge lets it in, it's in, whether it was admissible or not. So it's the party's determination to make sure that they're doing it. They've got to be timely, okay? And it must be made as soon as the grounds become apparent. For example, I just realized that this is the example on here on September 11th. Okay.
What a day to use that example.
Exactly.
Yeah.
Right? If the grounds are apparent from the question, right? It has been a member of Al-Qaeda. Right? The objection should be made to the question before it is answered. Right? If the question is innocuous and the grounds give rise for the first time in the answer, right? Do you recall anything else? Oh yes, Ben's a member of Al-Qaeda. Right? In that point, the objection is appropriate to the answer.
And what are you going to do? Move to strike the answer. If the answer's gotten out, it's out. You got to strike it.
It should be specific. Good objection should do 3 things. They should designate the item of evidence being objected to. They should state the rule, whether it's a prejudice rule or by number, like Rule 403. And if the rule has subparts, such as Rule 403, when we get to, you'll see evidence can be excluded because it's unfairly prejudicial or confuses an issue. Right? A good objection should tell the judge which of those subparts you're relying on. Okay, that's a good objection. If you said objection 403, for the most part, everybody would get it. Okay, and a judge is going to probably say that's timely and specific enough, and then you would argue accordingly. So, you know, just if you want to be really good and you want your record to be super tight, your objection should do all of those things. Okay? Motions to strike. The testimony is required if the jury has already heard the evidence. Right? Do you remember anything else? Well, yeah, Ben was a member of Al-Qaeda. Objection, sustained. And then you move along. That questions and answer are still there. Right? You've got to move to strike that answer. If you don't strike it, it's still there, it's still in evidence, and the jury can consider it.
This sounds really ticky-tack, but it's not.
Okay?
If you're right and that objection is sustained, you must move to strike the answer.
When you're responding, right? A lot of times responses are optional. Sometimes judges just rule. Sometimes judges will ask you to respond. Okay. Sometimes you'll want to respond. Sometimes the judge might rule and you, whoa, I'd like to respond to that. Yeah. So understand if you are responding, the same thing. Right? You should be responding with specificity as to why it is that question is okay, the answer is okay, or that item is okay. Whatever the objection is, and if you've done your homework ahead of time, before trial, you should already know the answer to that. Okay? Arguments by lawyers, arguments in opposition to and in support of evidence has to take place outside the presence of the jury. There are judges that will smack you down seriously and embarrass you in front of a jury if you try to make an argumentative objection in front of the jury.
That's sometimes called a speaking objection, where you don't just say the grounds of that you object and what the grounds are, but you start arguing and explaining why you're right. And some judges will let you get away with a little bit of that. Others will be like, that is not how we do it in this courtroom.
There's no way any of those items are admissible. Okay.
One other thing. Know your judge, right? I tell lawyers, when the jury's present, if you are speaking, you are standing. I don't want you sitting at counsel table and making objections. Stand up. When the jury's not present, I don't care. Do what you want. But I like things a little more formal when the jurors are present. Now, Mr. Nolan, I'll tell you, there are other judges, not such a big deal. Other judges, all the time. Go to federal court, you're standing up all the time.
You need to know it, and you'll develop your own practice, right? There are plenty of attorneys. Myself, Judge Hoffman was practicing, Dean Dolan, you'll never see them sit when they object, period, right? Because that's how they practice. They stand up when they're doing anything, okay? Just because the other side is doing it doesn't mean you do, right? You should practice the way you're taught to practice, and not necessarily lower yourself to whatever the other side is doing, okay? So, I had jury trials where defense attorneys sat the whole time, and there was no handicap or anything against you. He just sat, and he questioned witnesses, did it down the whole time. Wow.
And maybe that's okay, right? If the particular judge you're working with, that's okay, fine. I don't like it because I try to impress on, I think if the lawyers behave better and follow rules more carefully, it helps the jurors understand this is important. We have rules, we're following them. It's an important procedure. You need to follow the rules too.
Okay. The judge needs to rule. If there's an objection, the judge needs to rule. He needs to sustain it. He needs to overrule it.
And sometimes judges won't do it, and you have to push them to rule it. Why is that? Because some of us want to get lazy, or if I don't actually rule, guess what? I'm not wrong.
Yeah. And what does your record say? Objection. Counsel, move on.
Or something.
Okay.
Or interesting.
There was one judge that I really liked because he said the same thing. He's like, floor's open to you, counsel.
Yeah.
You know.
What does that mean?
Yeah. Objection. Floor's open to you.
I had a case of B.J. Bjork when I was a really new lawyer, and he was like, objection, but the field is open to you. Or overruled, but the field is open, or sustained, but the field is open to you. It's like, what the hell does that mean, B.J.?
Yeah. You know, if the appellate court's looking at that, what did the judge do? He sustained it. If there was a question and there was an answer, well, they've already heard the answer.
Yeah.
They didn't strike it. So the record is not clear.
If you've got an objection, make sure that you get a ruling.
Remainders, Rule 106, rule of completeness. If part of the document comes in, and it would be misleading if offered alone, the opponent may request a judge may rule that all available parts.
But again, this is only to written and recorded statements. If you find yourself saying, I'd like to offer the rest of the conversation, good luck. Unless that's a recorded conversation, it's not working.
Order offer of proof. Right? If evidence was excluded, the offering attorney wants to make sure that they put on the record why it is that this is relevant and admissible And the reason they're doing that is so that the appellate court has the full understanding of that particular piece of evidence.
And one way to do that is to tell the trial judge, look, I'd like to make a written offer of proof. Can I bring that to court tomorrow? Right? So that night you sit at your office and you write out, here is all the stuff that I would have gotten to put into evidence if I had been permitted to do so. And who are you writing that for? You're not writing it for the trial judge, and technically you are. But the trial judge has already decided you're not calling that witness and getting that evidence. You're writing that for the Court of Appeal so they can say, what was that moron thinking, excluding all that evidence?
And it's your job. Right? I've seen attorneys say, I tried to make an offer of proof and the judge didn't let me. Okay, and whose responsibility is it to make the offer? Judges or yours?
And maybe the judge isn't going to let you do it right then, right? We're not kicking the jury out so you can make a speech for 5 minutes about all this evidence that the jury's not supposed to hear because I just said you can't present. But later, when the jury's not present or in writing, you need to make that offer of proof. Don't forget it.
It's not enough to say, we aren't going to make an offer of proof. No. And the jury's sitting there and the witness is on the stand. You've got to understand your circumstances. Maybe at the close, when the jury's left for the day, or ask the court, can I come in? Can we put this on the record tomorrow? Or you put it in writing, which is so much easier. You get to put exactly what you want, okay? And it doesn't take any time out of the trial, okay? It's not enough to say, well, I asked to make an offer of proof and the judge told me nothing. So I moved on. Okay, it's your responsibility to protect your record. And on appeal, right, bad evidentiary rulings are rarely appealable. Okay? A couple of reasons for that. Can you imagine how anything would ever get to trial if every time before the trial happened, the trial court ruled, and then you appealed all of his rulings, right? And then the appellate court said, no, this is going to come in. Okay, well, why are we even having pretrial hearings? Why don't we just let the appellate court handle all pretrial rulings, and then we'll go to trial? Well, that's not practical. Okay, so the trial court has to rule, and the appellate court's not going to get involved in that. Rarely. Sometimes they will, but it's a rare occasion. A trial court has discretion. The rules give the court discretion. Okay, so unless they're abusing their discretion, they get to make the call. And the appellate courts aren't going to second guess it.
In abusing discretion, the standard is basically that decision was so bad, it's not just unreasonable, it's crazy. There's no rational basis for it.
Questions about our rules and objections and how you go about protecting your record and the like?
I don't really understand motion to strike.
A motion to strike is something has been said, an answer has been given. Judge, I want you to strike that answer from the record. Tell the jury to disregard it. It's no longer in evidence, it's been stricken from evidence. Does that make sense?
Okay, yeah, but reading the definition, people in here, it's saying that because they've already heard the evidence. So why does it matter if they hear it again?
They're not hearing it again. You're striking it so that it's no longer part of the evidence and it can't be considered. If it's not stricken, it's in evidence and it can be considered.
Because the evidence has already been ruled on, because that testimony had already been ruled on. So
Because the answer was already out.
Not that it was ruled on, that it was
that
given. The answer was given.
So now
Everybody's heard
so
it.
now it's in evidence. Pretend there's not a jury there, okay? It's in evidence. How do we get that answer out of evidence because it shouldn't have been in?
Okay.
We move to strike it. Now it's no longer part of the evidence. It's been stricken. Does that make sense?
Yeah.
And when it goes up on appeal, the appellate court doesn't consider it. If it hasn't been stricken and the appellate court's looking at the transcript, it's there. Now they've heard it, right?
Maybe a way to illustrate this, instead of talking about questions or whatever, consider an exhibit. This exhibit was offered, it was received into evidence. 2 days later, we find out through examination of another witness, oops, we never should have admitted that. In fact, there wasn't a proper foundation to it. When you finally got to cross-examine the witness on it, it turned out, no, he didn't really know what it was. Well, Your Honor, I'd like to move to strike Exhibit 12, right? Oh, okay, Exhibit 12 is now not in evidence. It's been stricken.
Makes sense?
Yeah.
Other questions? Remember, this is a building process. So right
Yeah.
now, we're on the ground floor. We're laying the foundation, right? Having this basic understanding of how evidence works, how it comes in, how you get it in, what it is, how you keep it out, is going to form the basis for how you analyze the other rules and fact patterns going forward. Okay? So if you don't understand this, as soon as we start getting into the rules, it's going to be more difficult to go back and say, I really don't understand this whole admission and exclusion process and how we do that. Okay? That's why we stress to you the simplest way to remember it. One question, one answer, one item at a time, right? Daniel, when you got that question, you're not evaluating that question, oh, there's 5 items of evidence. Can they all come in? No, you're not going to do a good analysis. Can the blueprint come in, right? Can the earring come in? Can the paintbrush come in, right? And you're analyzing individually, right? It doesn't make sense to try and do it any other way, okay? And that's how you have to attack it.
The opposing attorney knows what you're gonna bring, what you're gonna try to, admit as evidence.
Sure. You give
They
them
have-
In general, it's kind of hard to hide evidence.
yeah, you give them an exhibit list and a witness list and witness statements and, you know.
Which doesn't mean that you know, like, the impeachment evidence that you got necessarily. But in a civil case, it's really hard. In a civil case, everybody knows everything, at least if they've done even remotely half decent job of discovery. In a criminal case, the defense knows everything the prosecution's got, and the defendant's got to turn over stuff except impeachment stuff.
Sure, and kind of going to your motion to strike question, Daniel, I had a case where, you know, this defense attorney had an investigator go out and interview a witness and created this whole impeachment report. He had a report. And I thought I was right on the law, and I objected. I was, Your Honor, he's got a report. Counsel hasn't even provided me a copy of the report. Clearly, he knew he was going to use this impeachment. He was going to call, the investigator was on his witness list. He knew he was going to call him. I'm entitled to that report. Trial court agreed with me. Counsel, give Mr. Nolan a copy of that report. He did. I looked at it and I questioned him on it, and we came back the next day, and this was a good judge that knew the evidence inside and out. He came back the next day and he's like, I made a mistake. Mr. Nolan, would you please return that item? And this all happened in front of the jury. Because he just called him and he had that report and he was asking him, and you prepared a report and I objected, Your Honor, I haven't seen this report. And he told the jury in front of him, I made a mistake. When I make a mistake, I'm going to own up to it. The defense attorney did nothing wrong. He was right in keeping that report. He had no obligation to turn it over to Mr. Nolan. Mr. Nolan, would you please return your copy to defense, and jury, you're to disregard. Oops, okay. I thought I was right, and we all kind of thought we were right. And nobody really objected, but the judge went after hours and did his homework and said, yeah, he didn't have to turn that over. And he fixed it. He didn't have to. He could have came back the next day. We were already on to other witnesses and, nobody was making us think about it. It had already come and gone. But that judge took a very proactive role in making sure it was right. And making sure, clearly the impression would have been left that the defense attorney had done something wrong. He had hidden something from me. He hadn't turned it over, right? And I'm over there beating on my chest. How dare he, Your Honor? Right? We got discovery rules in this state. And he fixed it, or he tried to, Guy got convicted anyway. I don't know if that was because of that or in spite of that, but he did the best he could to try and rectify what shouldn't have come in, what shouldn't have happened.
So he struck it from the record, and obviously there was no way to file a motion to strike because.
Right, the judge did it on his own motion afterwards. But the big thing that he needed to address is, remember we talked about this idea of the jury's perception of you and whether they trust you and your credibility goes so far. And if that jury felt like that defense attorney had done something unethical and had hidden the ball, that could impact their case in a major way. And the judge recognized that and wanted to make sure that he told the jury this defense attorney did nothing wrong. He was completely within his rights and he didn't have to do that. Okay. And that goes nicely. Everybody read the article on ethics. We're going to cover ethics throughout as we're going through all the rules and we're going through things. We're going to talk to you about the ethics of evidence. That was, I think, an illustrative argument. Just know that there's these arguments going on out there, right? Right. The author talks about, he opens up how, right, one of his very first trials, the defense attorney had somebody else sitting at counsel table, and he lost, and the judge ruled that was okay. Probably wouldn't happen now, right? If somebody sat somebody else at counsel table, I think the judge would be extremely upset with that attorney, right? Because right, there's plenty of stuff on the record where you're saying this, my client's here, right? So it doesn't really, it's hard to do that now, but clearly in that case it was done. And what we want you to do is start thinking about your practice of law, okay? Evidence and how you use it and how you use these rules are going to define how you are perceived as a lawyer. Okay? And you're either going to be perceived as an ethical lawyer or somebody who skirts the line or somebody who just flat out crosses the line. Okay? And once you get that reputation, good luck getting it back. So we want you guys thinking about these things. Okay? And I think he does a good job of driving the point home that just because the rules don't preclude something doesn't mean that you should do it, that it's okay to do it. Okay? And it kind of gives you this idea that the ethics of evidence is more about the principles that you hold going in and how you go about your job rather than what the rules let you do and don't let you do. Right? And this idea is like, well, there's not a rule saying I can't do it, so let me do it. So I don't know if you guys have any thoughts on that, any questions on that. It really is just something we wanted to put out there, thought-provoking. It's a well-written article that kind of discusses the different theories out there. You can start keeping that in the back of your mind as you're evaluating these things. Okay? and hopefully you always err on the side of not just following the rules, but in doing so in an honorable way that upholds the respect of your colleagues and the courts. So.
He does talk about how difficult it is for defense attorneys to, it's the definition of knowing. What is the definition of knowing?
Sure.
So, I mean, how do defense attorneys work around that? What, can you give an example? Like your client comes into your office, you say, don't tell me anything.
Exactly.
Yeah, I was gonna say, there are lawyers, defense attorneys that I know who sit down with their clients and they say, okay, tell me everything.
Yeah.
And there are others that say, tell me nothing.
Sometimes it's, we're gonna talk about this case after I get the evidence from the prosecutor, right? And then you go through, we have this witness statement, these photographs and all this. But I don't want you to tell me your story. If I want to ask you about particular pieces, whatever, I'll do that. But once you tell me your story, that's the story I'm locked into, right? That's the story I now have to tell. If you don't tell me your story, then I don't know what the story is, and I can poke holes at the prosecution and suggest alternate theories of the crime and whatever, and whether they're consistent with what the client has in his head or not, doesn't matter, right? But once that client's told you, here's the truth, then you're stuck with that.
And those are things that you're gonna have to battle with yourself. And you saw it, he goes through a whole analysis. There's not a lot of good responses, right? You know your client's gonna lie. What do? Get off the case. Well, the judge won't let you, right? Tell your client not to do it. Well, he ignores it, right? Tell the court, right? He basically comes down saying, last ditch effort, if all else fails, you have an obligation to notify the court.
But
and you saw,
and then what happens, right? Because literally, the criminal defendant's got a right to get on the witness stand and lie his ass off. But you, as the defense lawyer, can't enable that by literally asking any questions. Get on the witness stand, go. And by the way, as a practical matter, this rarely works, right? Get on the witness stand, tell a bunch of lies. What's the prosecutor gonna do? Expose a bunch of lies.
So it's there's not a lot of good options. However, there's ways around it, and the good lawyers have, what would you call it, client control. They have the ability that their client actually respects them and looks up to them and will follow their advice. Right? If you're not a lawyer that holds yourselves out in a way that a client would want to follow your advice, they're not going to.
But even if you're the most ethical, upright, whatever lawyer, there are some clients that are just difficult clients, especially in the criminal defense arena. Yeah. And if you are assigned to represent that person, you do your best and play by the rules.
And you saw there are experts out there, right? Probably evidence professors who study this stuff and write articles and whatnot, who say that there should be a different standard for them. That's where you have to kind of decide for yourself when you're practicing. If you are a criminal defense attorney, how far are you going to go, right? How far are you willing to go? How far do you want to stretch this? Well, do I really know? Right? Well, anything's possible, right? So maybe I don't know. And you'll have to find that comfort level. But just know that if you make an error in a way that you get caught, it can be a career.
And seriously, what are the chances of getting caught? You're gonna get caught, right? Yeah, like, what was it, Body Heat, where the William Hurt character is buying a bomb from his client, former client who's in prison, and he tells me how to do it. And he says, you know, a smart person, obviously referring to the lawyer, told me there's 1,000 ways to screw, or 100 ways to screw up the perfect crime. And if you're really smart, you can think of 60 of them. So, you know, that's it. Well, you're gonna get caught. And with that,
Okay, everybody understand the syllabus underneath what we just covered tonight? Is your assignment for next week. And we will send you out the outline for next week and email. Okay? You notice the text sections you're reading? We're jumping to rules and you got a couple of problems there. All right? There's more there than it might look.
that's true.
All right, guys. Good night, and we will see you.
Tuesday.
So I need to take a look at these and see what we think of them.
Yeah.
You know, this one doesn't look like a textbook.
No, it's just one, that would be a supplemental there if we just wanted to use it.
Yeah.
And she said if we wanted, we can use that second semester.
Okay.
If we want to switch this to that, that would be next year.
Yeah, okay.
Oh.
That's good.
All righty.
See you later.
All right.
Night, guys.
I'm just curious, are we no longer recording? Are we recording or? There used to be a thing right here, and I see that it's gone, and they used to come in and we used to have to turn it on and turn it off, and I don't know if we are or we aren't.
That's back.
Is this recording? Oh, no. Yeah, there used to be a thing right there. Maybe we've got no online people. Questions will get easier.
We had it in the textbook? The questions we used.
Yeah, well, your analysis, you'll get how to analyze the questions and whatnot, and how to read the call the questions more specifically and whatnot. So, you know, you guys are in for a real treat in a couple of weeks. We got some guest speakers coming for my trial advocacy class, and I believe everybody's going to get to come in and hear them. And they are fantastic trial lawyers, ethical trial lawyers. You know, the type of lawyers like you put their names down, and if you guys ever get in any trouble, these are the lawyers you call. So you guys be in for a real treat. It'll help with some of this in context.
Is that on a Saturday?
No, it's on Thursday.
Oh,
It's on the day of our trial advocacy class. So whatever you have Thursday, the first half of that class, you'll probably be sitting with us. Unless your professor says, no, we're too busy, we can't do it. So, all right, guys.
Have a good one. Really? We were the last ones? How was it actually?
No, definitely not. You know what it is? It's like you have to have the program installed on your computer that's associated with this, so we can do it on a flash drive.
I always put that one in there. You might track your money. I didn't know.
Oh, that's good.
How much is it?
Saturday, I'll be.
They're on here already?
Yeah. But I couldn't check if it was successful or not, because
Bye, see you tomorrow. See you guys tomorrow.
Alright.
So that's everything.
Yeah.
I can do it.